I think is charged in this case, blank, 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 constitute criminal gang activity.
And then those are going to be, you can say they're defined further down. 'Cause I think you're getting into
So
those
that would be
definitions.
murder. And 57. So it would be murder and then everything listed in count 57. Possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, and possession of a firearm during the commission of a felony.
As will be defined for you.
So question here. Do you want me to say murder charged in counts whatever, or just murder?
No.
Okay. All right. So then that brings us to 2.1010, malice murder. Y'all say you agree, no changes. We've got some parentheticals, rather it's the unlawful intent to kill, and then you're supposed to only put the ones that apply. And the choices are without justification, without excuse, without mitigation. Is there any argument that any of those things has been established, even potentially in the evidence? No. Okay, so it would just end with the unlawful intent to kill, period. All right, premeditation, y'all are in agreement, motive, agreement. Possession of a firearm during the commission of a felony. Y'all said you're going to tailor it. Dude, let's just tailor it now. Had a firearm on his person or within arm's reach, right?
Yes, Your Honor, we charged it both ways.
While, there aren't any attempts, right, on the firearm things while committing the felonies of a crime against or involving another person, or a crime involving some of the drug stuff, right? None of the rest of them apply?
Yes, Your Honor.
Right.
Okay. And then the drug stuff, as I so aptly put it, would be possession or possession with intent to distribute.
Yes.
I guess the easiest thing to do would be just list those again. Possession of marijuana with intent to distribute, possession of marijuana or codeine with intent to distribute, or possession of cocaine.
Yes.
All right.
I'm sorry, could you give me that list again, Your Honor, that you just
So
read
do
off?
y'all want me to say, while committing a felony, which is a crime involving another person or a crime involving possession with intent to distribute or possession of those particular drugs, and then say, I charge you that certain of those drugs are a controlled substance, or just say, just get to the heart of the matter, which is if you find he did these things, then that would be possession of firearm during this type of felony. And then do I need to say, so my question is, do I say while committing a felony, which is a crime involving or against another person, murder is a felony, which I will define, or which I've defined for you, or do I just say while committing the felonies of murder or possession of these drugs.
I think the latter, Your Honor, is
Yeah.
cleaner.
It is
Yes,
cleaner.
I think so
It's
too.
simpler.
Everybody agrees?
Yeah, I agree with Ms. Sullivan.
Okay. So yes, it would just say, number 3, while committing the felonies of murder, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, or possession of cocaine. And that's it. And then for purpose of this offense, a firearm includes any handgun. Do we have rifle, shotgun, taser, or stun? I know we don't have the rest of them. Do we have rifle involved at all? Do we know?
No.
Not for these two counts.
No, Your Honor.
Okay, so for purpose of this offense, a firearm includes any handgun, period. All right, we don't need, excuse me, 2.42.00.
Your Honor, we do. Yes, we do, Your Honor.
We need it tailored to 133, right?
No, unfortunately, no, Your Honor. When we, in looking at the indictment, Your Honor, it looks like for count. For the two counts, count 63 and count 62, while we did charge 133,
Yeah.
it is missing an element. And
It's missing the indictment is missing an element.
Yes, Your Honor. And so we believe that the language as charged is a 131 charge and
So-
not a 132.
What's it missing?
It's missing the crime that they committed while being in possession of the handgun.
So I don't think y'all get a do-over on that right now.
But we believe that the evidence that's established has the elements
I
of
think it
131.
probably has potentially, but you charged 133. So if you get a do-over to do 106 or whatever it is, then you need to give me law that establishes that.
Okay, we'll get you law. Your Honor.
So either it's going to be, in my view, 133 or nothing unless y'all have law to change my mind. But assuming it's 133, I think it's possessed a firearm after having been convicted of a felony involving the use or possession of a firearm. And then I normally would have put blank as a felony involving the use or possession of a firearm. But we'll just hold off on that one until you come up with whatever law you're going to provide. Okay, possession of a machine gun. And I'm going to write this the same way the rest of them are written for whatever this offense is, and then here are the elements. Y'all dropped the language of the statute in. I'll just use those elements to do the kind of bullet point thing, okay? So it would say something like, the state must prove that the defendant possessed, or it's just possessed, a machine gun during the commission of those crimes. Okay. So Laura, just write me a note to rewrite it like the other ones are. Okay. 2.70.10. Y'all agree? So it's possession, right, of marijuana or No, it's possession of cocaine, right? Y'all help me out here.
The possession charge is cocaine and 60.
Okay,
Um,
so it's possession of cocaine. The statements prove that defendant possessed or had under his control cocaine, which is a controlled substance, right?
Correct.
All right, then moving to 2.70.14. For possession with intent to distribute marijuana, the statements prove the defendant possessed with intent to distribute any amount of marijuana. And because it's a separate count, I would then do for possession with intent to distribute a controlled substance. It would say to distribute codeine, which is a controlled substance.
Yes.
Okay.
Yes.
And you're right, can we, I'm sorry, I was typing, can we go back to possession of machine gun?
Yes.
If you did not say, and I apologize if you did, I think we need to define machine gun, which would be 1611-121.
Let me see what 1611-121 says. Does it give me a definition of,
Yes, it does, Your Honor.
well, that's very helpful. And obviously, I'll let y'all look at it again after. We put it together. Okay, so Laura, we can just go and lift that definition from that statute. It's in there. It's 1611-121. It's part of element 1.
My code section, got it, Judge.
Yeah. And then definition of marijuana, everybody's good with that. Did we have testimony that whatever was found was marijuana?
Uh, I don't believe y'all introduced any of the lab reports, did you?
Detective Storno testified that marijuana, now there's no lab test, that is correct.
Okay, well, anyway. All right, and then there is 2.76.10, actual and constructive sole and joint possession. Seems that everyone agrees. So we've got parentheticals.
Your Honor,
Mm-hmm.
the, I apologize for not, the GBI analyst who testified about all the pills, she also talked about she tested the marijuana.
Okay.
Okay.
So my state must prove that defendant possessed the marijuana, controlled substance, or gun, right? Or guns, gun at issue in this case.
I'm sorry, could you give that list again, Your Honor?
I mean, I would think it would be the marijuana, I can just say codeine,
Codeine.
cocaine, and guns, firearms, because it's a machine gun too, guns.
Yeah, firearm, there's a half a dozen roughly, so.
Okay, on equal access. I would think it would be the same list of things. Do you want me to read both parentheticals, possess and put those items?
I mean, I'm fine with just possess, Your Honor, but
All right, well, since it's your client that's facing those charges, although not with the guns. Just possess and not put the items where they were found. That's an interesting one.
well, I just don't believe there's been any evidence introduced of
We're just going to go with possess.
putting. Or possessing, but that's neither here nor
Okay,
there.
if, moving down to 27630, if you find that the defendant owned or leased the, where would, so
What's the second
Mr.
paragraph?
Kendricks is all the stuff that was found in Mr. Williams' residence, right?
Correct.
That's what he's charged with.
Yeah.
Mr. Stillwell is charged with what? The stuff that was found in the studio? Yes, no?
No.
What did I
Mr.
say?
Stillwell is,
Is it the reverse of that?
yeah, he's not charged with it.
Isn't he charged with possession of that possession of a firearm is if he committed the murder with a firearm.
Right.
Okay.
Mr. Williams, the thing that seems a little bit confusing about 27630 is it seems to be written from the point of view that one of the defendants is the owner of the residence. I don't know if.
It may not even be applicable.
Well,
I think
it-
it would be. I'll let Mr.
No. I think it would be applicable, but I think it would need to be altered somewhat because it's Mr. Williams that,
Well, I know, but that's better for Mr. Kendrick. If you find Mr. Kendrick owned the residence, well, he didn't. We all know that. Right? So then that part is not, I can read it or I can just not read that because it's not applicable.
yeah, okay, now I see what you're saying, Your
We
Honor.
could just say,
Yeah, I read it. So it probably isn't,
I just wasn't sure if instead of saying that the defendant owned an individual.
if you find that an individual owned or leased the residence
yeah.
where the all
drugs,
of that stuff
guns.
was found, then you may conclude that that individual possessed everything found there. However, if you find that others had access to the residence, then that individual, then the owner's ownership of the residence is not by itself enough to prove possession. Frankly, the whole thing's just not even applicable here.
Okay. You may,
Okay,
I don't object
so
to it
we
being
won't get
removed
that
then.
one at all. All right, affirmative defenses. The note is, defense believes this must remain. So I need some evidence
Go, Max.
to,
Mr. Stillwell keeps trying to trip me. So,
So he has no proof of that.
Your Honor, I am taking the stance that, well, again, if there's a directed verdict or if there's some issue with the gun charge, then that solves this problem. This relates solely to the gun charge.
Hmm.
We have heard testimony from the gang investigators as well as Investigator Thorpe. Woody's allowed to have a gun. Woody's allowed to have a gun to protect himself. People are shooting at Woody. It's okay if he has a gun. And my stance is that we've heard testimony that people are repeatedly trying to murder Mr. Stillwell. Mr. Stillwell is charged with possession of the FN 5.7 and he's charged with that. And our stance is, while it doesn't, it falls under F for justification, which is in all other instances based on similar reason and justice as those enumerated
Can
in
can
this
you
charge.
give me a second to find where that's, his count, what, 52?
52 and 64.
No, he's not even. 52 and 64?
Yes, Your Honor.
Well, 52, 54, that one doesn't chart, that just is the murder. 64.
It really applies, if he's convicted of 52, or whichever the first gun charge is that's associated with the murder, then that clearly wouldn't be, fall under instances of reason and justice. But for 64, when it's a standalone gun, we have laws in place under the jury charge 30110 for justification. And my argument is that the jury charge F is applicable under 30110. Unfortunately, what's complicated is to understand F, you
Okay,
need to,
hang on just a second. So count 52 charges that on March 14th, he possessed a gun, and that was the drinks murder, right?
yes,
Count 64 charges he possessed a gun on the 17th of March,
yes. And that was on Meadowlark Drive. The
when
gun
he
that
was arrested?
The gun
Right,
that was
right.
thrown.
The gun that the state is saying was thrown out the car,
Oh, which you've,
registered to Miss Alexander.
okay.
And my argument is if the jury finds that Mr. Stillwell was in fact carrying that gun around
Mm-hmm.
and either he or Mr. Nichols discarded it out the window, 30110 F would apply based, and the reason it would apply to him specifically is because we have heard testimony about repeated attempts on his life. Now, the dilemma, if Your Honor were to agree with me about F, the issue is that it's, F is a reference to A through E.
Mm-hmm.
So we would have to give them all A through E, but just
Well,
make sure that they understood that I was arguing F.
well, it would only be A. It wouldn't be any of the other ones.
Yeah, you know what, you're right, Your Honor, I'm sorry, you're right. It would just be F.
Okay, but here's the thing with the law is that if he had been possessing a gun despite being a convicted felon and somebody came up to his window and held up a gun to his temple and said, you know, dance or I'll shoot you, and he shot them instead, then he might be justified not only in shooting them, but in possessing the gun that would otherwise be illegal for him to possess. He couldn't be charged with that. Well, he could be charged. He couldn't be convicted of that. But here, he didn't do anything that was justified conduct. You know what I'm saying? Because it's a specific reference to 16:3, 21, 23, 24, 25, and 26, which is using a firearm in defense of self, home, others.
My understanding of I think it's a Johnson case. It's the one that the Hogues argued, and it was the first one that dealt with the situation that you laid out with possessing a gun and then using it in self-defense, even though you're not. My understanding of that case is that you would have a justification argument for the act, the murder, the shooting, whatever it is, but you could still, unless you grab the gun in a sudden emergency,
Right.
you could still be charged with the gun. The difference that here, from my perspective, is person in your scenario is just someone who's carrying a gun because they want to carry a gun and they're not supposed to carry a gun, then something unexpected happens and they use the gun.
Okay,
My
well, he
scenario-
knows somebody's after him.
Right.
Do
that's
you
the
have any
difference.
case law to support
There
your
is no
argument?
case law I've been able to find.
Making law, huh?
Yes, making law. Someone has to make it.
That's true.
But F exists for a reason.
I don't think there's any law that says that, I mean, especially if Johnson is a case that says unless, if you're a convicted felon, unless you grab a gun in an emergency situation, you're not excused. Your toting it around on your body doesn't excuse you.
For the gun possession. And that is in
Oh.
fact what Johnson says to
Okay,
my understanding.
well, I mean, unfortunately, potentially, unfortunately, there is not in the law any exception that says even a convicted felon who knows they have legitimate threats to their life, you know, can go to some government office and say, I've got legitimate threats. Let me carry this gun. That's
Well-
just not what the law is.
Of course, I'm going with the court and I respect the court. I would argue that that's what F is. That's why F is there.
Hmm.
Because it says in all instances based on similar reason and justice.
Hmm.
And to me, this is similar to 16, 3, 21, 23, 24 self-defense.
I mean, I like your argument. It's a
Thank
good
you.
legal argument. It's clever. State want to be heard?
That's just frankly not the law. I mean, the law allows us to, we could charge him with possession of a firearm during the commission of a felony or by a convicted felon 3 different times, knowing that he had it before and knowing that he had it after if he left with a gun, but he would be found immune from possessing the gun during the alleged whatever act he was justified in protecting himself with. But you can't just carry a gun around as a convicted felon and not be held accountable for it unless you are found to be justified in using the gun at the time in which you fired it.
All right, I am not going to give that charge. If you want to perfect the record any further, you can go ahead and do that. But I think it's pretty clear what your argument is.
Yes, Your Honor.
All right. So we will not be given 3.01.10.
In that case, and just for the record, I'm not acquiescing. I'm maintaining my argument, but just in all candor to the court, then we probably don't need 30000.
Okay, or 31010.
Correct.
All right. And we clearly don't need 31011 because it doesn't even exist anymore.
I don't think we need any of these
All right. I
justifications.
don't either because they all are like basically if they're, so no 1, 2 and no 1, 3. All right, then venue. Should be indicted and tried in the county in which the crime was committed. I'm going to strike the except as otherwise provided. We don't have that, do we? And then venue for RICO, y'all are both in agreement that the one that's listed is fine.
Yes, Your Honor.
Okay. Venue for conspiracy to commit a crime. Other than RICO, nobody's charged with conspiracy to commit a crime as like a separate offense, are they?
No.
So do we need this charge? Venue for conspiracy to commit a crime?
We would not seem to.
I don't think so either. Okay. All right, I need verdict forms or suggested verdict forms For 1.60.12, multiple defendants all, and it says adjust. Do we want that at all? What is anyone proposing on that?
I don't want that at all. Because I believe that is, I think that's covered in the next.
I mean, I'm going to tell them determine guilt or innocence of each defendant separately.
I don't believe that this is necessary.
Okay.
And I'm sorry, which part is not necessary?
1.60.12. Do we need that? This- It's, the defense is no longer requesting it if they ever did. Is the state still requesting that?
You said 1.60.12, correct?
Yeah.
Multiple defendants.
Right. Given that we're given the charge below about assessing the evidence against each defendant that the state requested.
We don't need 1.6.
All right. All right, assessing the evidence. It appears the state requested it. The defense is fine with it. And I assume the state still wants it, given that you requested it.
Yes, ma'am.
Okay. Court has no interest, no sympathy. Sentencing, responsibility for, state questions why I don't want to give that. Because if I'm telling the jury, don't concern yourselves with punishment, then why am I telling the jury anything about punishment? It's like, don't think about an elephant.
Because
It also seems to suggest that there's likely to be a conviction
well,
coming from the court.
I think because human nature, people will think we don't instruct them that they're not charged with what happens after the guilt innocent phase. And I think that's why this jury charge is important, because they may, in my experience, sometimes think about sentencing and think about what happens after this point, and am I responsible for that? So I believe letting
So if
them
they
know-
ask us that, then we'll say, don't concern yourselves with that.
I think innately, especially with a count like murder, where people know what the penalty is, that's typically what requests.
People think they know what the penalty is.
Right, but I guess because the people think they may know what the sentencing range is or what the penalty is, which is a life sentence. A lot of times that can come into how they view the evidence and things of that nature, and how it can be a factor in their decision making, which is why we request it.
To me, that's covered in sympathy. They're not supposed to have sympathy towards.
Okay, well, I don't ever give it, and I'm not giving it here. If they're not supposed to think about it, then I'm not raising that for them to then think about. All right, and nobody has any issue with deliberations or unanimous verdict. State, there's a note, state will be adding additional charge on consciousness of guilt flight. Do y'all have that ready?
It's not permissible.
Okay, well, we'll need to get that.
We're not.
Oh, you're not going to do it. Okay,
It can be argued, but it can't,
okay.
of course not, do a charge on it once the defense requests it.
All right, so jumping back up to wherever knowledge was. I don't know where it was. I think it might have been before the RICO charges.
Page 19.
Yeah,
Thank
page
you.
14310 on 19.
Okay, thank you. All right, so it seems that the knowledge that would be necessary for the drugs and the guns is explained within those kind of possession charges. Do y'all agree? Or what do y'all think? Anyway.
Our preference would still be to keep that knowledge charge in, especially, I understand that
I'm asking which crimes do I say it applies to?
the murder, the drugs, and the guns. Did I leave anything out?
I think D, all of the above.
No, I left out the RICO.
And, oh, the Rico.
And the gang, which.
Well, the
wouldn't
gang
even
is,
It wouldn't even make sense for the gang.
no, so the murder, the drugs, and the
Okay,
gun
so
genre.
knowledge on the part of the defendant that the crime of murder, I mean, I think it might be appropriate here to say murder in count, whatever, murder in count, whatever, possession of whatever it was, drugs in count, whatever. Do y'all think? Was being committed and that the defendant knowingly and intentionally participated must be proved by the state beyond a reasonable doubt. If you find that they had no evidence that the above listed crimes were being committed or that the defendant did not knowingly and intentionally participate or help in the commission of the alleged offense, I don't think we need conspirator there because conspirator gets covered in the RICO.
Yeah, we don't need that.
Okay. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of, list them again, and that the defendant knowingly helped or participated, then you would be authorized to convict the defendant of that count, I'm going to add that.
Yes,
Okay.
thank you.
All right, anything else we said we were coming back to? Obviously RICO, but anything else?
I sent a proposed charge to Ms. Percival and council as it relates to count 51. Mr. Stillwell is charged with 1654 subsection B. And I've sent a proposed charge as it relates to that count. It's not covered by the pattern.
That being gang?
So the pattern covers 16154A. It doesn't cover B.
Isn't that in our gang? It's, if you look at what's there,
It's already in there.
I'm sorry.
I did, where is it? Yeah, there's, to prove a violation of subsection A of the Gang Act as alleged in counts 50 and 57, the state must show blah. To prove a violation of subsection B of the Gang Act as alleged in count 51, the state must show it's all of those plus, in order to, there's an additional element number 4 in order to maintain or increase his status or position in the gang.
I'm sorry, Judge.
This covers that, right?
I completely.
Okay, it's okay. All right, anything else?
Could I have 5 minutes before you bring the jury out, Your Honor?
Yes, I
Thank
mean,
you.
we've got, oh, right. We told them 10. Do we know whether they're all here? They're not all here anyway. So yes, you can have until they get here.
Thank you.
We can go ahead and get the jury in. Thank you. Good morning. I gave Paul that mic with separate red on. Thank you. Everybody can be seated. Go ahead, Mr. Sharp.
Thank you, Your Honor. May it please the court. Good morning,
Good morning.
Investigator Viverito.
Good morning.
Are both those mics being used?
This one is,
Oh, it's fixed.
Yeah.
Okay, all right, thank you. So Investigator Viverito, where we left off yesterday, we were talking about a post that was captured by you that showed Quamarvius Nichols with some writing on the picture, correct?
correct.
Okay, we are going to get back to that later.
Sure.
Okay, so we're going to switch to another topic right now. But it is about the posts from March 2022 that you collected.
Okay.
Okay. The reality is in March 2022, you observed and collected some posts that you felt were relevant
Sure.
and that you felt were derogatory or mocking both the Christian McMiller and Darius Ford situation.
I'd have to see which posts were.
Well, we're going to get to individual
Okay.
posts, but some of the posts were derogatory and mocking Christian McMiller and Darius Ford.
correct.
And then you also pulled posts that you thought were derogatory or referencing or mocking Shamel Drinks' death. as well,
Correct.
Correct? Okay. And let's be clear. As an investigator, you are not saying just because someone posts something derogatory or mocking or referencing the death of another individual, that means that they committed that crime. You are not saying that, are you?
That is correct.
Okay. And I just want to talk to you about a couple of these posts. I'm going to bring them up to you, okay? These are all this is a bundle of the posts that you collected that are in evidence, correct?
Sure.
All right, may I approach?
Yes.
For instance, you observed some posts that were made following the Christian McMiller Darius Ford double homicide
Correct.
on March 10th going into March 11th. And these posts were in the days following.
Correct.
Okay. Ms. Knight, could you do me a favor and publish what's been admitted as 457 VV? Um, Investigator Viverito, this is a post posted by one ABG underscore Big Nick, correct?
Correct.
And you know this person from the picture and also from his name on Instagram to be Nicholas Johnson.
Correct.
Okay. And in this post, when was this post collected by you?
That was collected, would have been around 8:20 on March 11th.
March 11th. Okay. So this is the morning after Christian McMillan and Darius Ford were gunned down.
The evening, 8:20 p.m.
Oh, I'm sorry. Okay. The evening after.
Correct.
About 20 hours after, 21 hours, or 19 hours after.
Somewhere around there.
Okay. And this post includes a, says slime and chalk.
Correct.
Okay. And you viewed this as a clear reference to Darius Ford and Christian McMiller being murdered in reference to a chalk outline of a body on the street.
Correct. Coupled with my knowledge and interactions with Mr. Johnson in the past, yes.
Right. I think you testified that Mr. Johnson, in your opinion, he is associated with Atlanta Blood Gang.
He's documented as a member, and he's also a fixture at 12 Atlanta daily.
Okay. So you saw this post, posted the next day, referencing the death, mocking slime and chalk. Mr. Johnson has not been charged for the murders of Christian McMiller and Darius Ford, correct?
Correct.
And the reason he hasn't been charged is because posting something like this, while it is insensitive, while it may be wrong, it doesn't mean that he killed Christian McMiller and Darius Ford, does it?
Correct. There's other things we would look at, like if he was in the vicinity of the murder on camera, coupled with a post that's not great, that would be something we'd take into consideration, but that didn't happen.
And Investigator Viverito, I knew you were going to be dying to say that, and we are going to talk about all the surveillance videos and all of the situation involving Mr. Drinks when I get to it, okay? But I'm asking you specifically about posts. Posts that is not a confession to killing Darius Ford or Christian McMiller, is it?
Absolutely not. But as an investigator, you need to look at things as a whole to piece things together, leading you towards suspects.
Okay,
So,
and that's why you collected this.
correct.
Miss Knight, I'm going to ask you to publish 462 VV. Okay. 462 VV is two posts that showed up on this page labeled Joey_Hurst24, correct?
Correct.
All right. And on the left is Christian McMiller,
Correct.
and on the right is Darius Ford.
Correct.
And they're fairly self-explanatory. They're mocking the death of Mr. McMiller and Mr. Ford, correct?
Correct.
All right, and this was posted when?
I'd have to see the file name.
Okay, so you're not, and that's fine. Was it posted after the death of Christian McMiller and Darius Ford?
Yes.
Now, I understand your belief is that this is a trolling page or a fake page. Is that correct?
It's a page. Yes, it's a page that we had not seen surface really or be vocal until this point.
Now, and certainly when you see a page like this, there are certain investigative things that you could do to try to determine who is behind this page, correct?
Correct.
You could subpoena Instagram, you could check IP addresses to see who set up the page, etc.
You could.
Okay. You or anyone else that you know of did no such thing to try to determine who Joey Hurst was, the
No.
government name. Okay. And the reason you didn't, and I'm not trying to beat you up, the reason you didn't go through those steps, if you thought this was a confession, and you thought this meant that Joey Hurst killed Mr. McMiller and Mr. Ford, you certainly would have gone through those steps to uncover who it is behind this post, if you thought that was the killer.
If I thought that was, but the investigation led us to other suspects.
Okay. The bottom line is you did not view these posts as signifying that whoever was behind this account was the killer of Mr. McMiller and Mr. Ford. You didn't view it that way.
Correct. The individuals that were making posts who we deemed as suspects, they were further investigated, whether it be cell phone extractions or social media.
Okay. 456 VV. Please, Ms. Knight. Thank you. Okay, and this post was collected on March 11th, 2022 at 11:30 p.m., correct?
Correct?
Okay, so again, about a day after Mr. McMiller and Mr. Ford were killed.
Correct.
Okay, and you testified on direct about what you thought new op pack just came in. It's kind of like we're smoking on our ops.
Correct.
Okay. Certainly not kind, not nice, not sympathetic, and it's showing approval for what happened, correct?
Correct.
Okay. And this page is another one that you didn't know the government name of the person behind it.
Correct.
Okay, and you didn't go through any investigative steps, or anyone else that you know of go through any investigative steps to determine the person behind it.
Correct.
Okay, and the reason again is because this post, you didn't take it as a confession. You didn't take this post as saying, I'm the person who did it.
Correct.
Okay, cool. Finally, we're going to talk about Kelvin Watts.
Okay.
Okay, Kelvin Watts has not been arrested for the Christian McMiller or Darius Ford murder, has he?
He has not.
Okay. And this has all happened 2 years ago at
Correct.
this point. Okay. Really 2.5 years ago, more than 2.5 years ago. Mr. Watts made several posts regarding the death of Darius Ford and Christian McMiller.
Correct.
Okay. Ms. Knight, could you please publish 473 VV for me? Okay, in 473 VV, that's posted by Shell Kel Nutlife, correct?
Correct.
And you know that to be Kelvin Watts.
Correct.
And this was posted shortly after the death of Christian McMiller and Darius Ford.
Correct.
Okay, and this actually depicts Mr. Donovan Thomas.
Correct.
And underneath Mr. Thomas's left eye are 2 shells.
Correct.
Okay, and as an investigator, you're aware of like prison tattoos or eye teardrops under an eye, correct?
Yes, that's what I spoke about on direct.
Okay, right. And you took this as kind of a play on the teardrops under the eyes of 2 shells indicating 2 bodies, Darius Ford and Christian McMiller.
Correct. The first time we started seeing the 2 shells under the eye was after the death of Christian Ford and Darius McMiller, I think in days following.
Okay, Ms. Knight, could you please publish 461 VV? Okay, and here's another picture of Shell Kel or Kelvin Watts that posted shortly after the death of Christian McMiller and Darius Ford, correct?
Correct?
Okay, and these are, you got to look a little close, but I see the big shell off of his hair, but then there's two little shells under his left eye.
Correct?
Okay, and again, that's a post that you interpreted to be a reference to the death of Christian McMiller and Darius Ford.
Correct?
Okay. Ms. Knight, if you could publish 454 VV, please. Okay, in this post, again, shortly after the death of Christian McMiller and Darius Ford, correct?
This was in the hours after they were killed, yes.
And this is on Kelvin Watts' page.
Yes,
And again, we see the two shells,
correct?
okay, and that had significance to you because there was two dead bodies.
Correct.
Okay, thank you. And 460 VV, please, Ms. Knight. Okay, again, here, this was posted shortly after the death of Christian McMiller and Darius Ford.
Correct?
And we have two shells, right?
Correct?
And we have a smiley face, except the lips are zip tied or zipped up, I guess,
Correct?
and a black heart.
Correct?
Okay, and this was on Mr. Kelvin Watts' page.
Correct?
All right. Also, and Ms. Knight, thank you. Also, you're aware that Kelvin Watts has made a song that references Christian McMiller and Darius Ford, correct?
He may have.
You never heard Mafia Story by Shell Kel and Third World?
I haven't, but it would not surprise me if he did.
I heard my ops died like some thoughts, referring to two snakes dying with their eyes wide open and their tongues out. Crime scene nasty in a fast car, died in empty traffic.
That sounds about on brand for Kelvin Watts.
Okay, and that was a reference to the Kia Stinger, the fast car. It's Kia Stinger that Mr. McMiller and Mr. Ford were in.
That sounds about right.
Speculation.
Were Mr. McMiller and Mr. Ford riding in a Kia Stinger?
They were in a gray and color Kia Stinger.
Okay, and were they in fact shot on the highway?
Yes, they were on the highway.
Okay. Mr. Watts, despite these 4 posts that you collected and this song, has not been charged with the murder of Christian McMiller or Darius Ford, has he?
No, he has not, but that's also an open investigation that's not assigned to me. So
Okay, that's fine.
But-
So, but the answer is he has
He
not
has
been
not.
charged. And it's just 2 years, 8 months later.
it's still open active investigation.
Right, and you've had you collected these postings that Mr. Watts made way back in March of 2022.
Correct, but so investigations, just the social media posts aren't enough to arrive at probable cause. You'd need him maybe on video at the crime scene, before that murder, things of that nature. So if social media was enough for probable cause, a lot of people probably would have gone to jail for this, but we don't do that.
Right, because there were a lot of people posting on social media.
Correct.
A lot of people posting horrible things on social media.
But unfortunately, nobody was on camera at the scene or there, or there was no knife.
Agenda today, and I know that you want to talk about the security cameras, and we will absolutely talk about the security cameras. I promise you.
Commentary,
Absolutely talk about the security cameras. I promise you.
commentary, and
Well,
I'm
there's commentary going on both sides. Answer the question that's asked.
Okay, I want to clean up some, we're going to shift off of social media and we're going to get to the wiretaps.
Mhm.
Okay, I want to clear up some issues or not issues, I want to talk about the wiretaps and what we talked about Friday and yesterday. You had a wiretap. I understand you had one on Mr. Sumlin's phone. I'm not going to be talking about Mr. Sumlin's phone. I'm talking
Okay.
about Demekion Garlington. Okay?
Okay.
All right. Do you have the number for the total number of calls recorded or listened to during that wiretap?
I don't know off the top of my head.
Okay. Was it in the thousands? Is that fair to
Probably
say?
in the thousands, yes.
Okay. Do you know how many total calls Mr. Stillwell was a party to?
I couldn't give you a number, but it would probably be not as many as others because he went into custody, I think, within 6 days of the wire going up.
Fair enough. And just so we're clear, when you apply for a wiretap, you send something to the phone company, correct?
Correct?
And the phone company is told not to inform anyone about the wiretap, certainly not to inform the subscriber.
Correct.
So no one, to your knowledge, no one told Mr. Garlington that he's being recorded,
Correct.
okay? Because that would defeat the purpose of the wiretap, right?
Correct.
And to your knowledge, no one told anyone else that there was a wiretap on Mr. Garlington's phone.
Correct.
Okay. Now, the state referred to the calls that were played for the jury yesterday as a sampling. What was played to the jury wasn't exactly a random sampling of the calls, was it?
No, all of the calls were turned over, and it's my understanding that they had to be narrowed down.
Right. The state, in preparation of your testimony, they gave you a CD or some sort of flash drive with a number of calls that they chose and asked you to review them, correct? So you could speak intelligently about them.
Yes.
Okay. So it wasn't a random sampling, it was calls that the state chose to focus on.
It's my understanding that the prosecution and defense decided on what could and would be played. So it wasn't just random, let me pick 20 calls out of a bag. It was calls that were relevant to the
Right.
case.
Yeah, right. I'm just saying it just wasn't some random sampling.
Correct.
It was focused.
Correct.
Okay. And so let's talk about some of the calls. We're going to talk about specific calls in a minute, but if you go back to what was played yesterday on that wiretap of Mr. Garlington's phone, there were calls, repeated calls about keeping Miles Farley, who's a small man, right? He is a small gentleman, physically small.
Small, yes.
Okay. Talk about keeping Miles Farley from being violated or attacked at the Rice Street Jail, right? We heard several calls about Miles Farley and keeping him safe.
Correct.
Okay. We heard call, and do you have the call logs in front of you or anything?
I do not.
Okay. When you were testifying yesterday, what were you using to keep track of what calls which?
I didn't have anything in front of me.
Okay. Well, we heard call 2532 from April 3rd, 2534 from April 3rd, 2628 from April 4th, 3501 from April 13th, and 3697 from April 14th, all about Miles Farley and being in jail. Do you remember those 5 calls?
I do.
Okay. Was Shannon Stillwell a party to any of those calls?
He was not.
Okay. We also heard a call 3683 from April 14th about, and you could probably tell me who the people were. It was Demekion Garlington and someone about flying a drone into the jail, it seemed.
Correct.
Okay. Was Shannon Stillwell a party to that call?
He was not.
Okay. Then we also heard about Demekion Garlington going on and on about running into someone named Blizzy at some hotel in Cobb County.
Correct.
Okay. To your understanding, was Shannon Stillwell present for any of those events in Cobb County?
No, I believe he was in custody.
He
at
was
the
in
time.
custody. So he wasn't involved with any of those things that Demekian was talking about running the Blizzy in Cobb County.
Correct.
And then we also heard a call between, I believe, Demekian Garlington and Antonio Sumlin. And it sounded, and this was call 3171 and 3172 from April 9th, about seeing someone wearing some jewelry, and they were asking if you have a slider car with paper tags. It sounded like they were trying to come up with a way to commit a crime, a robbery, right?
Correct.
Okay. Was Shannon a party to that call?
No.
Okay. And Shannon was in jail at that time, correct?
Correct.
Okay, so he was not involved in that situation at all either, correct? All right, cool. All right. I'm going to talk to you about specific calls that have already been played. March 14th, 2022 at 9:59 p.m. It's call 335, okay? It's a call where you testified, I believe, and correct me if I'm wrong, it was a call between Demekian Garlington and a gentleman named DeMarco Boyer.
That is correct.
Okay, and that's at 9:59 p.m.
Correct.
Do you know how many 9:59 and how many seconds? Are you aware of that?
I would have to look at the log for the seconds.
Okay. And in that call, Garlington instructs Boyer to switch to video.
Correct.
Okay. Now, based on your investigation, you said Boyer was at the gas station,
Correct.
and you also said, well, you were about to say, and then I cut you off. Boyer, your investigation has concluded that Boyer was in Mr. Nichols' car.
Correct.
Okay, so, and you're basing that on your investigation. You're also basing on the fact that Miles Farley in that video, when he goes back to the car, gets into the back seat at the BP.
That and there are calls from the wire that
Okay,
say that he's in the car. Yes.
fair. So this call at 9:59 between Garlington and Boyer, your investigation is Garlington, this is your investigation, is Garlington is in Mr. Stillwell's rented white Audi,
Correct.
and Mr. Boyer, who's not charged in
Correct.
this case, is a passenger in Mr. Nichols' Ford Fusion.
Correct.
Okay, white Ford Fusion.
Correct.
Okay. Your investigation based on the time on the surveillance video from the FedEx surveillance is that the shooting happened around 10:01 p.m., correct?
I don't know if it's based on the time on the FedEx video.
Okay, well, what's your understanding of when the shooting occurred? If you know.
I don't know how they arrived at 10:02, but I know that's when both cars pull off shortly thereafter. Within probably a minute or two, the cars pull off from the gas station.
Okay. Now, what I want to know is, it's a matter of timing. The 9:59 and however many seconds that this call is made where eventually Garlington tells Boyer to go to video. That 9:59 and however many seconds is based on the clock used during your wiretap. That's where we get that time, right?
Correct.
Okay, so that's based on the wiretap time. Okay. So, and then of course, after they hang up, then do you know if there was a subsequent video or FaceTime call?
I believe you could see the data transmission come through
Okay, and do you know how long that call was or exactly when it took place?
immediately after, but I would have to look at the log.
Okay. And my question is, we have three different sets of time here. We have the wiretap time,
Correct.
we have the FedEx video time,
Correct,
and we have a BP video time.
correct.
Okay. Are any of those, to your knowledge, are any of those 3 separate surveillance systems synced up?
They're not, so typically what you would have to do is go back and sync them, because I know the wiretap is a constant. I know that's an accurate time.
Okay, so you know, and that's fine. So you know the wiretap is an accurate time, but we don't know if the FedEx is an accurate time or the BP is an accurate time.
I'd have to look at the timestamps on both.
Okay, so I guess what I'm getting at is we can't just go by the BP time and go to 9:59 and however many seconds and say, oh, that's when that call was placed.
I went off of the wiretap data.
Right, exactly.
Correct.
Right, and that's what you were in charge of the wiretap. You went, but I'm going to go back to my question, and that makes complete sense to me that you went off the wiretap time. But we cannot go back to the BP and look at the BP at 9:59 and however many seconds and say that's when this call was made, because those 2 timing systems between the wiretap and the surveillance might not be synced up.
Correct. I'm not sure if they were or they weren't, but typically that's something I double check.
Okay, and the same thing for the FedEx. We can't look at the FedEx time and just go to 9:59 and however many seconds and say, oh, this is the exact time when that call was between Mr. Garlington and Mr. Boyer, between those 2 cars was made. We can't do that, can we?
Correct. I go with what I know to be constant.
Gotcha. So all you're saying is 9:59 on the wiretap.
Correct.
Awesome. Okay. Mr. Atkins or Miss Knight, and I should ask you, could you please publish what you played yesterday at call 350? I'm going to ask the questions first. Thank you. So, yeah, I'm going to give you a couple minutes. All right, I'm going to talk really slow because I got to give Mr. Atkins a couple minutes. Okay. So we listened to another call at 2:01 a.m. between, do you know who that call was between?
I'd have to hear it.
Okay, well, I'm gonna cut to the chase. You said in court that you heard someone say riding by the scene.
I don't know if I said that verbatim, but they're riding back through, I think is the direct quote.
And you said the scene.
They may have been riding back through the scene.
Okay, well, do you now know what call I'm talking about?
I know which call you're referring to, yes.
All right, and if you, and do you know who the speakers were?
Well, if it's from the wiretap, one would have been in Garlington.
Right.
And then I believe the other one may have been Boyer. I have to hear the call. I don't want to misspeak on it.
Okay, and people were fussing with each other. Someone was fussing with someone about not having a ride to get back to where they needed to go is essentially the gist of the call, correct?
Correct.
All right. Now, if you could play, if you could publish, right, and whatever, okay. Yes, if you could just publish, and I'm going to stop after about 40 seconds.
Bro, who that was? Nah, the nigga Ray got it, not Dan said got it.
Okay, could you pause it?
Oh, for real?
All right, now, Miss Investigator Riverita, do you know who the speakers are?
I believe it's Boyer, but I need to hear a little bit more. That was kind of muffled.
That's fair. All right, Miss Hilton, if you could.
Yeah, RP, the YP Ray. Yeah, I don't even know him. That who got his chain snapped? That who changed little J5 to Jason? Oh, for real? Yeah, the YP Ray nigga. Oh, I ain't even know that. Yeah, that little PLK nigga. Oh yeah, I had a J5 with me last night. That's probably what it was. Yeah. Yeah, that who changed it. Oh damn! What I say? Yeah. Buddy came and followed me. I followed his ass back. Hey, talking about what fuck wrong with him? What you talking about? I'm trying to get the other care data address right quick and care address. He testing the young crew. Somebody he finna send a bit. For real? Somebody he gonna send a bit somewhere late where the spot at.
Okay.
Yeah. He told LJ you got liquor last.
20 seconds. And my notes might be wrong, but I don't think they are.
Definitely page 350.
Yeah, 20 seconds, please. Could you just tell me when you hear anything about the scene?
Okay, go
Oh,
ahead.
for real? Yeah, the YP Ray nigga. Oh, I ain't even know that. Yeah, that little PLK nigga. Oh, yeah, I had a J5 with me last night. That's probably what it was. Yeah, okay. Yeah, that was.
Oh, no, I'm sorry. Yep, okay, I'm sorry. You're going by the different number. It's 2:01 a.m.
It's page 357.
Right, it's the PD, to call 350. All right, here we go. This is the one I meant to pull up for you, Investigator Viverito.
Yo. All right, man. There was all kinds of shit going on. I just jumped in the other car, bro. Y'all niggas don't be getting dropped off and they ain't got no motherfucking ride to go back home to. That don't make sense. Yeah. The fuck you getting dropped off for a nigga ride with a nigga who wrote you? Yeah. That's stupid as fuck. So, you need to be on the damn hill, so. What the hell? What's on with you? We're right here down here. Yeah, what? Ride past around the sea.
Okay, stop. Did you not just hear him say riding past through the city?
He said riding past trying to see.
Well, where's the scene?
I said,
You said scene before, now you're saying trying to see, and I'm saying city.
you may have misunderstood what I was saying. Or you got to understand when these calls come in, when you click on the call, it will also provide a map of where they are. And the next call may show where they traveled to after that. It's my understanding that he traveled back towards that area.
Okay, but towards the area, you mean the city? It's in the city,
They never
right?
left the city.
Okay. Investigator Viverito, you previously testified that he said going to the scene, and now you're saying to this jury that he didn't say scene, he said see. Is that correct?
I don't know if I said he said, I don't believe I said he said he's riding through the scene. He may have rode back. I believe he was traveling back towards the scene.
And I know you're an expert, but if the jury listens to this and hears city, is that okay with you?
But that's not what's said. So I would clarify for them.
I understand that you want to tell everyone what's said here, but you've already given two different stories. You said see, and then you said
What's your
see.
objection?
Argumentative.
Overruled.
It's
Can we just go by what we hear? Is that okay?
sure.
Thank you. Okay, call 416, and I don't need this published. Thank y'all. It's from the early morning hours of March 16th, 2022. Okay, there was actually two calls that were played. Do you recall?
Correct.
Okay, one is Mr. Garlington and someone that you say is my client, and the person's whispering. I'm not even going to dispute it, okay? We'll just say it's my client.
Okay.
Whispering about hiding in the crawl space.
Correct.
Okay. And then the second call is Mr. Garlington and my client talking about what just happened.
Correct.
And of course, what just happened was the house was shot up, and then a bunch of police officers showed up, and no one was arrested.
Correct.
Right. Okay. So, and that was the same day, of course, that you spoke to Shannon Stillwell. You put him in the back of the police car, or someone put him in the back of the police car, and you spoke to him, and he told you he was, in fact, driving the white Audi.
Correct.
All right. So, that call, let's just review some things that were discussed by Mr. Garlington and Mr. Stillwell. They talked about their amazement about not being hit by any of the bullets that were fired into 2830 Waters Road, correct?
Correct.
They talked about their amazement that the police let them go from that location.
Correct.
They talked about how they hid from the police.
Correct.
Mr. Stillwell talked about being placed in the police car.
Correct.
Mr. Stillwell said that he denied knowing McMain when asked and said he was from Thomasville.
Correct.
Okay. That was misleading, right?
Correct.
Because he does in fact know McMain.
He does.
All right. And McMain, just so we're clear, is Christian McMillan.
He is.
Yeah. And he talks about getting out of there as soon as possible. Like speeding away because he couldn't believe that y'all, the police, let him go.
He does, but he says prior to leaving, he collected his FN and his rifle or stick and he left.
I'm going to get there. Okay. And they talked about seeing you too, right?
They did.
All right. So let's talk about, I know he, in that call, and clearly I'm getting there, he talked about sneaking his FN away from the scene, right?
Correct.
And about sneaking his stick out of one of the cars. I think the gray car.
Correct.
All right. Okay. Now, the FN, you've testified, you know that an FN 57 is registered in Miss Taisha Alexander's name, correct?
Yes.
Okay, and that gun was located at Meadowlark Drive on March 17, 2022,
Correct.
correct? The next day after this call.
Correct.
All right. Does that FN shoot 40 caliber bullets?
Does not.
That could not have been the murder weapon for Shamel Drinks,
No.
could it? Okay. He talks about taking a stick from a car on the scene, right?
Correct.
And you know the stick to be an AK-47 type assault rifle, correct?
Could be an AK-47. It could be an AR-15. It could be, it's a rifle.
Typically shoot 7.62 caliber bullets.
Correct.
Okay, not 40 caliber.
Nope.
Okay, so you would know that that stick that he talks about taking from the scene once you guys let him go is in fact not the weapon used to shoot Mr. Drinks.
Correct.
All right. And in this call where, again, you don't have any reason to believe Mr. Stillwell knew he was being recorded
Correct.
or Mr. Garlington knew he was being recorded. In this call, he never talks about taking any other guns from the scene.
Correct.
Okay. Okay. Call 2119 is another call that was played. It's from April 1st, 2022 at 12:29 a.m. It was a call between Demekion Garlington, who's on the wiretap, and Shannon Stillwell, who's in jail at this point, correct?
Correct.
Okay. And Demekion is on his normal phone, and you testified that Shannon Stillwell, when you're in the jail, you said there's wall phones, right?
Correct.
Okay, and that's, the jury has heard those recordings where they talk about Securus and this phone will be recorded, and they are in fact recorded.
Correct.
Okay. Mr. Stillwell was not on a recorded line.
Correct.
He was on a cell phone from the jail.
Correct.
Okay, so he, in common sense, he doesn't know that Demekion Garlington is being wiretapped.
Correct.
Okay, and he has no reason to believe that the cell phone he's using from the jail is being recorded.
Correct.
It's fair to say that they believe that they're having a private communication that is not being recorded.
Correct.
All right. Mr. Atkins, could you do me a favor? This call 2119, and I'm talking about at 12:29 a.m. Could you play on April 1st, 12:29 a.m. You know how to make consult with the?
Yes.
state? $240 to $315 is what I'm up. We're just gonna queue that call up, okay? And I'm gonna ask you some questions about it.
Sure.
Thank you, Mr. Atkins. And if you could queue it up to 2 minutes and 40 seconds. $240.
I don't tell them folk, bro. I'm like, shit, what the hell they locked up for? Like, they just saying about the camera. I'm like, bro, they good. I'm just like, they gonna assume some shit like that anyway. You feel me? They gonna assume that, like, oh, like, y'all ain't did nothing, you feel me? So,
That's what I keep telling goddamn Lil. I keep telling him like, just chill. Like I know, like
cause they
this
saying
ain't
he panicked.
nothing. Yeah, I'm like, this ain't nothing, bro. Like they just doing that cut. They seen as a goddamn gas station. Like just chill. You see what I'm saying?
Yeah. Yeah, yeah, man. That's what I'm telling. I keep telling him all the same shit. I'm like, listen, bro. Just like you, like, bro. I'm telling probably in the cat. Listen, bro. No, just tell him for you don't want to talk, bro. Like,
Not one word.
yeah,
Other than what they try to portray or what they say, man. Don't say shit.
yeah. I ain't know that though. Like, so I didn't have my, I need to have.
Okay.
Yeah.
And you can keep that up because I'm going to ask you to play another part. But thank you, Mr. Atkins. So on that call, again, neither party has reason to believe they're being recorded. That's Demekion Garlington and Shannon Stillwell.
Correct.
And they talk about they gonna assume shit.
Correct.
Mr. Garlington says y'all didn't do nothing.
Correct.
And then Ms. Stillwell says they just saying it because they seen us at the gas station.
Correct.
Okay. Mr. Atkins, if you could please play 11:20 at 11:28.
Yeah, man. What the hell swimming on? You still in the yo?
Yeah. Okay, what is that?
You know what I'm saying?
Yeah, see.
Who?
Who?
Yo, folk.
Yeah. Okay, what is that for them?
We're gonna come back to that one because I want to get the timing right.
Okay.
What's that?
Okay.
Okay, and that is, Mr. Coker. You go first. Okay, and we're gonna come back to that call. But let's talk about Mr. Stillwell's phone that was collected.
Sure.
Okay. Do you know you're able to view? So you collect the phones. Detective Leon Packer, he dumps the phones, and then you're able to view the phones, what the contents of the phones through a program called, what's it called? XRZ, is that correct?
XRY.
XRY. Okay. And you get just a whole bunch of information that's in whoever's phone. Pictures.
The contents of the phone are organized by category.
Right, and we're talking about pictures, text, emails, instant message, call logs, location, data, internet searches,
Correct.
notes.
Correct.
Okay. And if you don't know, that's fine, but do you know how many texts or calls total were in this phone?
I don't know off the top of my head, but it would be listed on the extraction, on the front page of the extraction. When you open it up digitally, it'll give you what you're going to see initially is it's everything by category. So it'll say 20,000 texts, 100 calls, things of that nature.
Okay. Ms. Knight, if you would please display 227 VVA2. Oh, Ms. Knight, that's it. VVA2. Yes, VVA2. 227 VVA2. A. Okay, this is one of the text messages or one of the text conversations that was introduced on Friday, I believe, correct?
Correct.
Okay, and this is from Mr. Stillwell's phone.
Correct.
All right, and in this phone, Mr. Stillwell's talking to, is that D, do you know that number to be Demekion Garlington?
I believe so, yes.
Okay. Because there's a couple of D's in this case, but you believe this to be Demekion Garlington?
He did change his number right before the wiretap, so I believe that's the number before.
Okay. And if you could zoom out a little bit, Ms. Hilton. Oh, Mr. Atkins, so we can see the whole conversation. Thank you. Thank you, Mr. Atkins. So in this conversation, to add context, Mr. Stillwell is indicating that one of his two phones is at Big House.
Correct.
Okay. Do you take that to be Darius Ford's house? And again, let's be clear, this conversation occurred December 24th, 2021.
Okay.
Okay, so we're talking about 3 2.5 months before any of this involving Christian McMiller's death or Darius Ford's death or Shamel Drink's death occurs.
Correct.
Okay. Do you take that to be Big's phone? Is there another Big? Do you not know?
There is another Big.
Okay. So, but in any event, Mr. Stillwell is saying he left his phone at someone else's house.
Correct.
Okay. And then D says, finna take it in where you at, indicating that he's taking Mr. Stillwell's phone, right?
I don't take that as taking the phone, like finna take it in, like I'm finna go to sleep or go home.
Fair enough.
Like take it in for the night.
Fair enough. Could you go down, Mr. Atkins? Okay, and this is the part that the state introduced. Okay. He says, if Polka asks, tell her I'm op hunting. Okay, he did not say I'm op hunting.
Correct.
He said, if Polka asks, tell her I'm out hunting.
Correct.
Okay, and Polka you know to be who?
Taisha Alexander.
And that is Mr. Stillwell's girlfriend at the time.
I guess, yes, I don't. Yes,
Something
at the time,
like- something like
sometimes, yes.
And you also know from your review of the calls that Mr. Stillwell was having some issues with fidelity.
Yes.
Okay. So he's just saying, if Polka asks, tell her I'm op hunting.
Correct.
All right. Thank you, Mr. Atkins. Mr. Atkins, can we go back to that call? I think I finally got my stuff together here. Okay. Remember that call that we were just talking about with, and just to review, it's Garlington and Mr. Stillwell, and they were talking about people were going to assume things, and they're just saying it because they saw us at the gas station.
Correct.
Okay. I want to play, Mr. Atkins, if you could start playing it. I guess we could start at 11:28. Yeah, 11:45. Yeah, that's fine.
Yo, folk.
Yeah. I was there with him yesterday.
Yeah.
Yeah, he got out of town now. So he's gonna get ready to come back. I was gonna lie with his ass.
Yeah. You ain't talked all night. That whole night crazy, bro.
Yeah, I just talked to her today. I talked to her today.
Man, that be
I
crazy.
was telling her, I'm like, he on the cell phone, like, he probably be over there, like, what, not? She's like, what? You only think you gonna tell on me? I'm like, man, hell nah.
She crazy. I don't even be texting that back no more.
I should be testing on, like, on the tablet and shit.
Yeah, I don't even be responding to that. That crazy.
Yeah.
Hey, look, I'm finna get bro back his phone, right? I'm gonna get up with you though.
I do that, man. I
All
got
right,
you.
love you. All right,
I love you too.
all right.
All right. Well, okay. Let me just ask you this, and we're going to get it together, and we're going to get it played. Do you remember on that call, that same call, that unrecorded call? I mean, that these two gentlemen thought that they were talking to themselves without being recorded. Do you remember Mr. Stillwell saying, when they test for gunpowder, it's going to come back clean?
I do.
Okay, and that's on this call.
Correct.
All right. And he does not say the car has been cleaned.
Correct.
He's saying, don't worry about it because when they test for gunpowder, it's going to come back clean.
Correct.
Okay. And that was on the private call between Mr. Stillwell and Mr. Garlington that they had no reason to believe was being recorded.
Correct.
Okay, I'm going to go back to the phone. You made note of 227 VVB11, and we don't need to display it, but it was basically something in Mr. Stillwell's notes that said, "Pop my shit. I really got options. Poor little ops. They be dropping."
Correct.
Okay, and that was in March 15th, 2022 at 12:52 a.m. The phone says that that's when it was entered.
It might say either modified or entered, yes.
Okay, and that was, and we're going to get to it, but you're aware that Mr. Stillwell's grandmother, Betty Jackson, texted him about the shooting, about seeing it on the news that night?
Objection, assuming facts not.
Well, it's going to be in evidence. I'm asking if she's aware. You're aware of that?
I was aware that Miss Alexander notified him about a shooting in Mechanicsville. I don't know if Miss Jackson did.
Okay, it was hours, this would have been hours after Miss Alexander alerted him as well, correct?
Okay.
Correct?
I'd have to see it. I'm not.
Okay. All right, well, we'll get to it, but this was at 12:52 a.m.,
Okay.
right?
I haven't seen it, so I
Okay, and we've already discussed ops,
Correct.
dropping ops. Those are common themes, common topics of drill music, correct?
Correct.
Okay. And at the time, your investigation, at the time that he entered this note into his phone, he was in fact at the studio, correct? At 12:52 a.m. on March 15th.
After leaving the gas station, they went to a studio. I did not have location data on Mr. Stillwell to say, but I believe they should have still been at the studio.
Still been at the studio creating music when he entered that note.
Creating music, hanging out. Like, yeah, that's what they do. Hang out at the
Okay.
studio.
All right, cool. And then you talked about search words, a search that you noted about a Windsor Street shooting, right? That was in Mr. Stillwell's phone.
So he didn't, and I clarified that on direct. He
Right.
didn't search Windsor Street. He searched Fox 5
Okay.
and then
Well-
clicked on, and then within Fox 5, then searched the Fox 5 website.
I appreciate that. So on 3/17 at 2 in the morning, Mr. Stillwell clicked on the Fox 5 website to this article.
Correct.
Okay, didn't search, your testimony is he didn't search words like Windsor Street or anything, but he clicked on the article and that's what shows up in the phone.
I'd have to see the screen. I believe he searched Fox 5, traveled to the Fox, like say I open my phone and I want to go to whatever Amazon. I search Amazon, click on Amazon, and then on Amazon, I would then search. That's what happened. So he searched for Fox 5, went to Fox 5, then went on Fox 5, I believe searched Windsor Street shooting, and then clicked on the article, is what it looks like.
Okay, and Miss Knight, could you just display 227 VV88 so everyone knows what we're talking about? Okay, so this is what you're talking about, right? The search.
Correct.
Okay, that's and this is 3:17 at 2:31 and 56 seconds in the morning, correct?
Correct.
No, that's fine. I want to show you some documents, investigator.
Sure.
That's okay with you. May I approach, Your Honor?
Yes.
Investigator Viverito, I am approaching you with what's been marked 57A, DS57A, DS57C, and DS58. Could you look at these and tell me if you recognize?
Sure. Okay, these are excerpts from Mr. Jackson's phone.
Right, and those are, well, and are those excerpts from, are those conversations from the data that was downloaded from Mr. Jackson's phone?
Sure, the first one is the one that I spoke about that I had seen of Miss Alexander informing him about the shooting.
It's not a new,
Oh, sorry. Yeah.
Are those accurate representations of the data that was in Mr. Stillwell's phone?
Yes.
Okay, Your Honor, at this point, I would move to admit 57, DS57A, DS57C, and DS58 into evidence.
A, C, and E. Say that again, please, if you don't mind.
It's, and there is no DS57B. It's DS57A, DS57C, and DS58.
Oh, okay.
Yeah.
Don't know where the E came from. Okay. Those are admitted.
Mr. Kokomo, could you please, or permission to publish, Your
You
Honor?
may.
Mr. Kokomo, could you please publish 57A first? So in this, in DS57A, investigator, this is a conversation between Taisha Alexander, also known as Polka, correct?
Correct.
And Mr. Stillwell.
Correct.
Okay. At 3:14:22, at 11:01 p.m., Miss Alexander reaches out to, or texts Mr. Stillwell and says, "You okay? Somebody just got killed in the Ville. Ugh." Or ugh. Atlanta, too much right now, right?
Correct.
All right. And then they respond to each other with kisses. Mr. Stillwell asks who got killed, correct?
Correct.
And then Miss Alexander eventually says, "I don't know yet." But before that, she sends some sort of screen message, correct?
Correct.
Okay. And that's at this, the message is sent at 11:19:47 p.m., correct?
Correct.
All right. And Mr. Kokomo, if you could publish 57C. And this is the screenshot that, or the picture that Miss Alexander sent to Mr. Stillwell at 11:19 p.m., correct?
Correct.
And it's a photo, and is that Windsor Street?
I believe so.
And it's captioned, "Somebody just got killed in Mechanicsville."
Correct.
And it's posted by someone named Bori Billions.
Correct.
And whenever Miss Alexander sent this picture or downloaded it, it already had 2,000 views, correct?
Correct.
All right. So by that night, just based on what we see in this phone, by that night at 11 o'clock or 11:15 or 19, the word had spread about a shooting, correct?
Correct.
In Mechanicsville,
Correct.
where someone was killed.
Correct.
Okay. And this was not a secret. It was being spread throughout social media.
Correct.
Mr. Kokomo, if you could post DS58. Okay. this is a conversation, and I'm sorry, it's marked 58A, so Your Honor, if we could just amend that to make 58A.
Sure.
Thank you. So looking at DS 58A, this is a conversation between Mr. Stillwell and Boss Lady, correct?
Correct.
And you know Boss Lady to be Betty Jackson, correct?
Correct.
His grandma.
Correct.
His grandmother who raised him.
Correct.
At 11, Mr. Come on. Thank you. At 11:19 p.m., Shannon texts his grandmother, "I love you."
Correct.
Boss Lady or Betty Jackson responds, "Mama love you so much, heart, heart, kiss, 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 'cause you're my sweet thing."
Correct.
And Mr. Stillwell says, "Yeah." I don't know if I'm pronouncing that right, but yeah, right?
Sure.
And then Miss Jackson gives a thumbs up, right? And then at 11:26:57, Miss Jackson says to Mr. Stillwell, or texts Mr. Stillwell, "Hope you are not near Windsor Street shooting on the news," right?
Right.
And then she says, "Answer me, please."
Correct.
And eventually at 11:41, 15 minutes later, Mr. Stillwell responds, "I'm at the studio, Mom."
Correct.
Okay. So at 11:26, according to this conversation, not only did Miss Alexander alert Mr. Stillwell about the shooting on Windsor Street, but Miss Jackson says there's a shooting on Windsor Street, right?
Correct.
And it's on the news.
Correct.
Was this information about the shooting on the news at that point?
I know that the article that Miss Alexander had, that's a female, I don't know her real name, in Atlanta, that wasn't like an ATL scoop or a news thing. And then I don't know how Miss Jackson saw it, so I'm not sure if you got word of mouth from Miss Alexander, worried about it. I don't
Maybe
know.
she saw it on the news. Maybe
I don't know when the news coverage began.
Okay. The bottom line is by 11:26 that night, two different people had informed Mr. Stillwell about a shooting, a death, Windsor Street,
Correct.
and the word had spread throughout. It wasn't just Mr. Stillwell that was being informed. The word had spread throughout the Atlanta community that quickly.
Correct.
All right. And basically, the phone indicates on March 17th, 2 days later, Mr. Stillwell clicked on a news article about that shooting.
We sought out the news article and then clicked on it.
Okay.
Yeah.
He sought out and clicked on it.
Correct.
All right. Cool. All right. Right when you started testifying, you remember when you were going through a timeline, and I think it was from 2019 to 2020 different events that had occurred?
I do.
And we heard a lot of names, Tanquarius Mender, right?
Correct.
And you said he's a member of the Rolling Crips.
As well as YSL, yes.
Okay, and we heard about Stephen Harris,
Correct.
and he's a Crip. And we heard
No,
about,
I'm sorry, Stephen Harris is a member of YSL.
okay, he's a member of YSL. We heard about Marcus Sims.
Correct.
He's a Crip.
Yes.
Okay, we heard about Wayne Alford. And we heard about a bunch of other names in this
Correct.
timeline that you were going through. Well, first of all, let me just ask you this. When you were asked about all these events, you were referring to some sort of, you were refreshing your recollection with a sheet that was in front of you.
Correct.
Okay, that was highlighted, color-coded.
Correct.
Okay, did you create that sheet?
Mr. Abadi had created the sheet as a timeline.
Okay, so when you were testifying about those events, you were refreshing your recollection. You were being asked questions by the prosecutors, correct?
Correct.
And then you didn't have any reports of your own with you, did you, about any of these events?
No, I didn't. I was at the GBI at that time and they were APD cases, so they wouldn't be my reports.
So you didn't investigate any of these events?
So the way it would work is gangs typically doesn't take an aggravated assault or a homicide or things of that nature. We will work with those units and provide them information and assist with their investigations. So the reports, I will help with the cases, but they would fall with those investigators.
Did you have any reports with you when you were of your reports with you when you were discussing those?
No,
Okay. But you were refreshing your recollection off of a sheet of paper that was prepared by the prosecutor.
well, this is something we had discussed. There's numerous incidents, so we needed a timeline to keep them correct.
All right, well, let me just ask you this. In all those things, 2019, 2020, that you discussed, all those events, Shannon Stillwell wasn't charged with any of those events, was he?
He was not.
Okay, cool. Remember when you talked about how I was asking you about your reports and you said you write them in search warrant applications?
Correct.
All right, I want to talk to you about that. You did a search warrant application for the house of Jeffrey Williams on 355 Allison Drive, correct?
Correct.
Not moving the evidence. I'm going to ask you some questions about that affidavit. Would having your affidavit that you wrote
Sure.
up there with you, would that be helpful?
Sure.
May I approach?
You may.
Okay. These affidavits that you fill out to take to a judge to try to get a search warrant, they're under oath?
Yes.
Okay. A judge relies on them, relies on the accuracy of them, correct?
Correct.
Relies on them to be complete.
Correct.
The intent of an affidavit is not to mislead a judge, is it?
No,
Okay. And you wouldn't mislead a judge, would you?
I would not.
Okay. And you filled out this affidavit on May 9th, 2022, correct?
Following the presentation to the grand jury, yes.
Right, May 9th, 2022?
Correct.
Yep. And that was also in the wake of these various attacks on Lucci, on Rashawn Bennett in the jail,
Correct.
okay? In fact, you were interested, you had that one with Jada Myrick, with Mr. Eppinger and Mr. Sumlin, and Mr. Eppinger was trying to get Mr. Sumlin to talk to someone to get payment, right? And you suspected that person to be Jeffrey Williams.
Suspected, and that was confirmed by Mr. Sumlin.
Okay, so you suspected that to be Jeffrey Williams.
Right, and was confirmed by Mr. Sumlin, yes.
Okay, again.
Yes,
just
I
please,
suspected,
just
yes.
questions I ask, okay? So you saw a search warrant for Jeffrey Williams' home for evidence on these matters, correct?
No,
Okay. You saw the search warrant for Jeffrey Williams' home.
for his body, for his cellular devices, and for gang evidence.
Okay. Okay. So, in Mr. Williams' home.
Correct.
In your affidavit is what's used to develop PC or probable cause for the judge to rely on, right?
Correct.
And in your affidavit, I think it's in the 4th page, you reference a post that you saw on the internet about Jeffrey Williams posting YFN, and this is already in evidence, YFN, if ain't like what you do for your mother and kids, I would have been killed you, right?
Correct.
That's referenced in your affidavit.
Which page is not on 4?
Well, mine's not numbered, but I'm just gonna go by. Right, it's on the 5th page, I'm sorry. If we count, and again, they're not numbered, but I'm just going by the 5th page that I have.
So
And it would be the first, it would be the second full paragraph. So there's one sentence and then 2 paragraphs down.
1, 2, 3, 4, 5.
You can look at my, may I approach?
Yes.
Right.
Okay, that's different than what I have.
You reference seeing on XXL this magazine, you reference seeing this post that Mr. Williams supposedly made, correct?
Correct?
Okay, and that made your affidavit because you thought that was important to show Mr. Williams and his veiled threats to Mr. Bennett, correct?
Correct.
Okay, cool. Can I have that back? I'm just gonna need it.
Sure.
I'll bring it back to you. Now, you also, 2 pages after that, whatever page you have it, I have, in the beginning, it says details 4.
I'm gonna have to see the page because these pages are out of, whatever I have is not the same as yours.
You can have
Okay, no, I see that one. Okay, I got you.
it. All right. Also in your affidavit, you include a text thread between Mr. Wooney Lee and Mr. Williams, correct?
Correct.
And as part of this text thread, you draw the judge's attention to a specific line, correct?
I included that amongst other things in the affidavit, yes?
Well, there's one particular line that you put in a bigger font and you also circled it, or it's circled, correct? On these,
It's circled, yes.
okay. And you circled it to draw attention to it, correct?
To what I was referring to, yes.
Yes. And the line that you circled to draw attention to was YSL rule the world, kid, 24M on an N head, correct?
Correct.
Okay. And you wanted to highlight that passage said by Mr. Williams in the text thread, correct?
Correct.
You wanted to highlight that for the judge.
Amongst other posts, yes.
Okay. What was he referring to? Why did you feel it important to highlight 24M on an N's head to the judge?
Well, he's referring to YSL ruling the world
Yeah.
as an organization, and it could be a play on words or a play on things that have happened, saying 24M on a racial expletive head.
Okay, 24M on a racial expletive head. It sounds like Mr. Williams had money on someone's head.
It could be taken that way, yes?
It could be taken that way, and you highlighted it and circled it for the judge, correct?
Correct.
Okay. And you believe that too. You wouldn't have misled the judge about what was being discussed, would you? You believed that to be a threat, didn't you?
I didn't say it was a threat. It's saying that he's willing to, that's how they talk. They'll talk about, they have the ability to put money on people's heads.
Okay. Mr. Kokomo, could you please publish Jeffrey Williams 3 and 4? Is that correct? Okay. Could you please publish Jeffrey Williams 3? Oh, before you do that, in this thread that you highlighted in your affidavit to the judge, this thread between Wooney Lee and Mr. Williams took place on February 7th, 2021?
Correct.
You just started over, Mr. Kokomo, with volume. All right.
It's we can put 24M on the front of your head. Y'all young hoe get in line. Slime rule the world. Believe it. Y'all niggas out this motherfucker spending 24 million on their heads. We can put 24M on the front of your head. Y'all young hoe get in line.
Okay, and could you please publish Jeffrey Williams 3A? You see, what's displayed is Jeffrey Williams 3A.
I do.
Okay, and it's a reaction, Jeffrey Williams reacting after Lil Uzi Vert put a $24 million diamond into his head.
Correct.
Okay. Did you know about Lil Uzi Vert and the $24 million diamond and that reference when you filled out this affidavit?
I did not, but I would still stand by what I put in the affidavit.
Okay, so you're telling me right now, on a sworn statement to a judge with knowledge that Lil Uzi Vert just got a $24 million diamond put into his head the days before Mr. Williams typed that, you would still put that quote, YSL ruled the world, 24 million on an N head in that affidavit?
Objection. They compounded, made a mischaracterization of what the witness just said.
Overruled.
I did not have knowledge of Lil Uzi Vert getting a diamond in his head.
Okay, so all right, so let me ask that last question again. Instead of saying I would do it again, if you had knowledge that Lil Uzi Vert just got $24 million diamond in his head and that Mr. Williams was referring to that, would you still have put that in the affidavit?
Yes.
To mislead the judge?
Not misleading. May I explain?
Yes.
Okay. What I'm saying is this social media direct message is different than what you see on here. Lil Uzi Vert, I don't remember, is a member of YSL. So I think it might be a new, like a term they're going to coin, like wipe his nose, things of that nature. So 24 on somebody's head might be a new thing that they're going to go with. He's saying YSL rules the world. As the leader, he can make that assertion.
You're doing a lot of explaining. Did you do any of that explaining in your sworn affidavit to the judge?
The sworn affidavit reads, Jeffrey Williams brags that YSL rules the world and has $24 million.
Okay. And clearly, when you put highlighted and circled 24M on a N's head, you're sending a message to that judge, are you not? Let's be real.
I'm referring to my words that I wrote say, Jeffrey Williams brags that YSL rules the world and has $24 million.
All right, and just so we're clear, as we sit here today, as someone, a law enforcement officer, even with knowledge of this, you would still put that in front of the judge?
There are different interpretations to everything as we've seen throughout this whole trial.
I agree. Can we make our determinations, or are you going to make the determinations for us?
Objection. Arguments is
Sustained.
you think maybe you misinterpreted what was said by Mr. Williams? Is that a possibility?
I think it differs from what was presented on the internet and between direct messages, as we've seen.
So your answer is no, your interpretation is perfect, pristine.
My interpretation was YSL rules the world and they have $24 million. That's what I wrote in my words in the affidavit. I didn't say Mr. Williams has $24 million on YF and Lucci's head. I didn't say that. I said YSL rules, he claims that YSL rules the world and has $24 million.
No, you didn't say it. You just put in a bigger font and circled it for the judge, right? Right?
It wasn't a bigger font. That's how the message reads. It's the same font as the date and time, the same size as the date and time as the name, the Instagram handle.
In the circle?
It's circled, correct.
Let's talk about you, Ms. Knight, could you pull up 227 VV A6B? Thank you, Ms. Knight. Yesterday, you indicated that, now this is from a video,
Correct.
with Mr. Nichols,
Correct.
rolling a blunt.
Correct.
Okay. And then there's other individuals there, correct? There's other individuals in the room?
Correct.
Okay. And then it's on Mr. Stillwell's phone, so you're presuming that Mr. Stillwell was filming the video?
It was filmed from his device. So
Right,
yes.
right. Okay. So yesterday, you made a claim that a gun, well, what did you say? A gun is, I don't want to jumble your words. What are you claiming about the guns on this table?
A gun is what?
You identified or thought a gun was consistent with something?
It could be consistent with a Glock 27.
Could be consistent.
Correct.
Okay. And which gun is this?
The one towards the back right here.
Okay. Could be consistent with a Glock 27. All right. It could also, well, first of all, are you a firearms expert?
I'm not.
Okay. You're just someone who's owned a Glock before.
Several, yes.
Okay. And before yesterday, had you ever made the claim that, oh, I reviewed this video and this appears to be a Glock 27?
That was my first time testifying yesterday, so where else would I make?
What about reports? Did you ever write a report and said, I reviewed this is very important. I reviewed this video that was in Mr. Stillwell's phone, and I believe that that could be consistent with a Glock 27.
Well, while reviewing the evidence in preparation for trial, when I took a better look at this video and found it, it was probably 2 or 3 days before I testified. And that's when I first had to really research through and look at photos and kind of isolate what kind of gun that was.
So the answer is no, you didn't write a report.
No.
Okay. And certainly the first time saying it to me or anyone on this side was yesterday in court.
Correct.
Okay. You say it looks like it could be consistent with a Glock 27 based on the shape of the bottom of the grip. Is that correct?
Correct.
Okay. It could also be consistent with a Springfield firearm, correct?
I'm not familiar with a Springfield, but from how the magazine looks, also it could be consistent with a Glock.
Okay. It could also be consistent with a Sig Sauer. Could also be consistent with a Smith & Wesson, correct?
I'm familiar with a Glock.
Right, because you're not a firearms expert.
I
You're
never-
only familiar with these Glocks.
I never
And-
claimed to be, Mr. Sharp.
kind of making yourself an expert, but you're not an expert, are you?
I'm not.
Okay. And you don't even know, whatever this gun is, if Mr. Stillwell left with that gun or didn't leave with that gun. You don't know if anyone left with that gun. You don't know whose gun that is.
Correct, but we don't know that they didn't.
Okay. Right. Let me ask you this about your Glock 27 that you say this looks consistent with. When you shoot your Glock 27, does it expel shell casings?
I don't own a Glock 27. When I was purchasing a subcompact Glock, I was going back and forth between the 27 and the 43. I prefer to shoot a 9mm, so I went with the 43.
So you don't even own a Glock 27?
I just said when I was researching the two, handling the two at the gun dealer.
So now you don't own a Glock 27. You were researching it, which means you were handling the gun at the gun dealer. That's your experience with the Glock 27.
I never asserted that I owned one. I've seen one. I've handled one. I can recognize one.
So you've handled one at a gun dealer, and that's what you're basing the identification on.
I've recovered a good bit of guns in my
Okay.
career. I know what they look like.
All right, let me ask you this. Since you know about guns, at least through your career, Glock 27s, when you shoot them, do they expel shell casings?
Yes.
Okay, Glock 27s, when you shoot them, do they make a loud bang?
Yes.
When you shoot a Glock 27, does it create a muzzle flash?
It should. I mean, when you
Okay.
shoot it, like during the day, you wouldn't see it, or sometimes at night you can see it, but
Okay, and when you shoot a Glock 27, does it emit gunshot residue?
if it's inside of a contained area, yes, it would.
Okay. All right. Remember on Friday, you talked about you get to the end of an investigation, something seemed small is huge. And we were
Correct.
talking about the post. All right, well, there's one thing, surveillance video. You would agree that that starts huge and remains huge? Like
Every-
surveillance video is a pretty important part of a case.
Every investigation is different, but yes,
Okay. You've seen the BP video, correct?
I have.
And you've seen it, Detective Hogan showed it to you?
He did for the purpose of identifying the individuals, yes,
Right, okay. Have you seen the FedEx surveillance video?
I have.
Okay. I'd like to watch it with you. Is that okay?
Sure.
Mr. Kokomo, if you could keep it up. Okay, before you start, Mr. Kokomo, investigator, when did you first see the FedEx video?
It was after I met with Investigator Hogan in the afternoon of the 16th, so it would have been after that.
Okay. Well, are you aware that, and maybe this will help you answer this question, you're aware that Detective Hogan swore out warrants against my client without ever viewing the FedEx video?
I can't speak to what he did or did not do.
Okay. When did you most recently watch the FedEx video?
Probably maybe like a week ago,
Okay. How many times in total have you watched the FedEx video?
a few times.
A few times. When you say a few times, how many is it?
And I've watched it a year ago, or a couple years, like 2 years ago. I watched it.
Mr. Kokomo, if you could please publish the FedEx. Okay. Go ahead, Mr. Kokomo. Mr. Kokomo, if you could pause that video right now. Thank you. Investigator Viverito. At this point in video, as we have it paused, you would agree that Mr. Drinks's red Versa is on the left, correct?
Correct.
Okay. You would agree that Mr. Stillwell's rented white Audi with tinted windows
Correct.
is in the middle. And you would agree that Mr. Nichols, actually Miss Lewis, Mr. Nichols' wife, that Ford Fusion is on the right, correct?
Either the right or staggered behind it, yes.
And according to your investigation, Mr. Drinks is alone in the car,
Yes.
okay? Mr. Stillwell is in the car with Mr. Garlington per your investigation.
Correct.
And Mr. In the car, the Ford Fusion, we have Mr. Nichols driving,
Correct.
Mr. Boyer,
Correct.
and Mr. Farley.
Correct.
And your theory is that while at this light, Mr. Stillwell shot Mr. Drinks, correct?
I'm not the homicide investigator, so I'm going along with the evidence that was presented to me by homicide. But yes, that's consistent with what Detective Hogan, his case.
Well, you know, he swore out a warrant for Shannon Stillwell for actually shooting Mr. Drinks.
That's consistent with what Detective Hogan had found.
In this video, you could see headlights, correct?
Correct.
You could see traffic lights,
You can see tail lights and traffic lights, yes.
and you could see brake lights, correct?
Correct.
Awesome. Mr. Kokomo, could you just play the video? And I'm just going to ask you to look at the cars closely.
Mm-hmm.
Okay, pause, Mr. Kokomo, please. All right, so we're paused at 102:36 on this video. At this point, Mr. Stillwell in the white Audi is pulled off, correct?
Correct.
Okay, and Mr. Nichols and with Mr. Boyer and Mr. Farley have pulled off.
Correct.
Okay, while they were there at that light with Mr. Drinks, did you observe any muzzle flash on that video?
No, and with this quality of video, I would not expect to see it.
Okay, right. You just see brake lights and traffic lights and headlights, but no muzzle flash. Okay, I got you.
A muzzle flash is much, much, much dimmer than a brake light. Like if you're shooting at night, you're hard pressed to see your own muzzle flash.
Firearms expert again.
I'm telling you, my experience from shooting a fire, and we do take night firing courses.
Okay. So let me ask you this. Gunshot residue. You aware that the headliner from Mr. Stillwell's car, the Audi, was collected and tested for gunshot residue?
I am.
You ever talked to Alexander GBI analyst Alexander Coven about the results that he found?
I have not.
And you are aware that warrants were taken out certainly before any of those GSR results were in, correct?
Correct.
Talk about tint. You've been preparing with the state. You know that the state has said that Mr. Stillwell had tint applied to his windows of that white Audi upon renting it, correct?
Correct.
In violation of the rental agreement, I may add.
Correct.
Okay. And this tint was applied on Flat Shoals Road, according to the district attorneys, at about 6:30 p.m.
According to them, yes.
Okay. You were able to observe the white Audi on March 16th?
I did not walk. Wasn't that interested in it at that point, so I did not walk. It was very, very dark.
Have you seen the pictures that Miss Antoinette Green took of the white Audi after it was recovered when Mr. Stillwell was arrested?
I have.
Did you see any damage to the tint, specifically the front driver passenger tint on that car?
I did not.
Mr. Kokomo, if you could rewind again. No, actually, you know what? I'm sorry. Keep it here. Keep it here. Just play it. I'm sorry, Mr. Kokomo. Okay. You saw that car speed up behind Mr. Stillwell? Pause it, please. You saw
Yes.
that? Mr. Stillwell, you're aware that he, well, you've already stated this, he was victimized in the past. Someone shot through the rear windows, killing Tiara Jones.
Yes.
And now that car that sped up is next to Mr. Drinks, correct? Or approaching Mr. Drinks?
It's approaching, but it stopped short of Mr. Drinks.
Okay, Mr. Kokomo, if you could please play it. Okay. So now there's a pause. So now there's one car next to Mr. Drinks, correct?
It's still not next to him. You could see from the angle that it looks like the front of the car. I'm sorry. The front of the car is like, from what I can see, looks like the front of the car. The front wheels are still towards the back of the vehicle. It's not like exact with the car.
Okay. Mr. Kokomo, if you could please play. Pause. See that car make a U-turn?
I do.
Okay. What car was next to Mr. Drinks when that car suddenly made a U-turn?
Judging by how the lights are, that car still appears to be back a little bit, but next to it.
All right, so now you're making three-dimensional evaluations, but we can't see a muzzle flash off this.
A muzzle-
AMV.
Mr. Sharp, I'm going to explain to you. When you're, and I don't know if you're mischaracterizing it. When you go to the range, example, to fire your weapons at night and there's a line of shooters, it's not bam, 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 lights everywhere. It's a very, very muted, if it shows. So this far away with this quality of video, I would not expect to see that.
Okay, well, let's talk about this car.
Sure.
This car makes a U-turn. Did you see, is there like a train that's crossing that would have let this person know, no, I need to find another route?
No.
Is there a officer saying, hey, turn around, you can't come this way?
No.
Is there an animal crossing the road that would have made this man do a U-turn?
No.
Who is this? Whose car is this that made the U-turn?
I don't know.
Okay. Do you know if anyone ever tried to use these license plate readers to determine whose car that is so we could talk to them about why they made that sudden U-turn?
That would be part of Detective Hogan's investigation, but I do not.
Okay. Could
does the map link do?
It will show you, if it's available, the map of where the device is located at the time of the call.
Okay, we click on the map. And if you can use the pointer. Looking at the map, are you able to see the area or the neighborhood that that it appears that the phone is in?
Yes,
Okay. What neighborhood is that?
Mechanicsville. It'll be all right here.
And where it has the pin drop, is that where the phone is supposed to be located on the map?
It should be within that radius. So it'll give you a radius and say within this many meters, and that judges how big the circle's going to be.
And on the radius, do you see Fulton Street Southwest?
I do.
And do you also see McDaniel Street?
I do.
Is the is I-Windsor and I-20 in this general vicinity of this area?
No, it will be right here.
I'm going to object to vague general vicinity.
Sustained.
Within the map, are you able to see where the I-20 Windsor area is?
Right here.
Are you able to see, court's indulgence for a moment? Thank you. Now, do you recall Mr. Shar asking you about whether or not the phone call that was at 9:59, where the call says get on FaceTime, whether that was, where did you get that time information from?
Yes.
And where was it that you received that time from?
The wiretap itself.
I'm going to publish for you what's already been admitted as 397 VVD, which is the ankle monitor location information. Looking at 397 VVD, do you see a time for 9:59 p.m.?
I do.
And do you see a location for 9:59 p.m.?
464 Windsor.
I'm going to show you what's been admitted as 397 VVC. Do you see that same address located on 397 VVC?
I do.
Okay. And is that the BP is that the BP gas station?
It is.
And is that the BP gas station located at Windsor and Fulton Street.
It is.
Is that the same BP gas station that you saw in surveillance video?
It is.
Is that the same BP gas station where the car that was rented by Shannon Stillwell and Demikion Garlington is inside of is at that gas station?
It is.
Is that the same gas station where the white Ford Fusion is in, that DeMarco Boyer is in, at that same gas station?
It is.
And is it at 9:59 that that call comes in that for them to get on FaceTime?
It is.
And in looking at the surveillance video, is that moments before or after the red car in which Mr. Drinks was in is pulling off from that gas station?
I'm gonna object to possible speculation. I
Have,
don't know how the video cameras link up.
I think that's an argument.
Do you want to rephrase the question?
Sure. On the surveillance video, do you see at approximately 9:59 from the BP surveillance video, that car, Mr. Drink's car leaving the gas station?
I believe Mr. Drink's car leaves the gas station and the other cars shortly thereafter follow.
And then do they then go to, those cars go to the light that's on the FedEx surveillance video?
Yes, they stop at the light.
Now let's go to the FedEx surveillance video.
Sure.
Right? Now, what time is on the surveillance video on the bottom? How much into the video are we at?
1 hour, 1 minute, and 32 seconds.
All right. Mr. Bott, if you can press play, please. Is that the red car approaching the light?
It is.
Right. Is that now the first white car, which is the white Audi, now approaching next to Mr. Drinks?
It is.
And is that the white Ford Fusion then approaching next to the white Audi?
It is.
Okay. And are those cars just all at the light currently?
Yes.
And do we now see cars moving in the opposite direction?
Yes, oncoming traffic is starting to move.
And actually, Mr. Abadi, can we go back to when the cars first get to the light? I want you to tell me, I'm investigating River, what time does the red car first get to the light?
One hour, 1 minute, and 36 seconds.
What time, and tell me what time the Audi gets to the light?
At the 45-second mark.
And what time does the Fusion get to the light?
52-second mark.
What time does oncoming traffic start?
1 hour, 2 minutes, and 11 seconds.
Are they still at the light?
They are.
What time does this car that's behind pull up?
1 hour, 2 minutes, and 24 seconds.
Do you see the white Audi pull off?
I do.
What time was that?
You may have to roll it back for
Okay,
a second.
if you can pull back for a second.
You may have to go back more because it's already pulled off.
You can go back to 102.11. We'll pause. Do you see the Audi pulling off?
Foot comes off the brake at about 1 minute and 1 hour, 2 minutes and 21 seconds, and they pull off at 1 hour, 2 minutes and 24 seconds or 23 seconds.
And prior to the Audi pulling off, do you see the Fusion make any movement?
No,
Okay, let's go back. Can you go back to 102:15?
oh, the Fusion starts creeping up.
And what time is that?
It's around like the 17 or 18 second mark.
And is the white Audi going into oncoming traffic?
Yes, it darts into incoming traffic, oncoming traffic.
The lane that Mr. Drink's car in, is that the left turn lane?
It is.
The car that pulled up behind, does that car go left and turn left?
Yes,
And you said that you've been out to this area before.
I have.
Is the middle lane a turn lane?
No,
Is it only the left lane?
yes.
Now, if we can go back again to 102:15. Now, investigator, I want you to focus on, remember the individual you saw walking in the video before?
Yes.
I want you to focus on that individual walking.
Okay.
And when if you can show the jury when you first see the person walking.
Right there. Or is it not on my screen? It is. Oh, there it is.
And you keep playing. Do you still see the person walking?
I do.
Are they still walking when the car makes a U-turn?
It is. They are.
Can you still see them walking?
It's muffled, but yeah, they're still continuing towards the intersection on foot.
And is Mr. Drink's car still sitting in the left lane?
It is.
Do you still see the individual walking?
You see, surfacing right here. It's very hard to see, but you see the movement right here.
And he's still walking towards the light?
Correct.
On Windsor Street, where the individual is walking, what is to the right of where he's walking?
I believe I remember correctly, some bushes or shrubbery, and there may be a wall of some sort. I can't 100%.
Now, we're going to have to go back again to about 1:02:11. Again, is that where all three cars, the Fusion, the Audi, and and Mr. Drink's car, all at the light?
Correct.
Now let's focus our attention on the car that pulls up. What time does the car pull up?
At about the 27 to 28 second mark at 1 hour, 2 minutes, 27 or 28 seconds.
And I actually want to pause. Mr. Abadi, are you able to zoom in to that portion now? And once you zoom in, if you go back to 10211. If it's not working, we can just go back. Thank you. Is that just a zoomed in area of the location that we've just been looking at?
It is.
All right. And now I'm going to focus on the white car that pulls up. Do you see the fusion pull for it first?
Correct.
Is that the Audi pulling off into traffic?
Correct.
Now, is the white car behind those cars?
It is.
And from here, can you tell if the car that pulls up is behind the car with Mr. Drinks?
You'll see like a gap here. It's like the tires are back towards the back of the car.
In the turning lane?
It's in the middle lane.
Okay. Keep going. And do you see the car flash on and off and the car still behind Mr. Drink's car?
Yes.
And is that light red?
It is.
And does the light turn green when he goes to make the left turn?
It is.
Following road traffic
Correct.
or following the correct signals?
Correct.
And is the car still sitting there?
It is.
At any point in time in this video, do you see any muzzle flash?
No.
But was Mr. Drink still shot inside of that vehicle?
Yes.
Now, when the Audi that Mr. Stillwell takes off, does he go left as well?
Yes.
Right. I want to go back to 397 VVD. And I want to go all the way up to the top initially.
Okay.
This exhibit. Now, do you see the categories of the information that's contained within this exhibit?
I do.
Do you see column I?
Yes.
And what does column I say?
Speed.
All right. I want to go back to March 14th, 2022. And I want to scroll to when we last looked at this document at 9:59, was he at the location at 464 Windsor Street?
He was.
Okay. And at 10 o'clock, was this at 464 Windsor Street?
He was.
That's the same BP gas station.
Correct.
All right. At 10:01, was the income miner at 405 Cooper Street Southwest?
It was.
Right. And do you see that column I where it says 17 and 18?
Correct.
All right. And that's in miles per hour, right?
Correct.
When we go to 10:02, PJV2 plus VR, is that at 18 seconds?
18 miles.
18 miles per hour?
Yes.
Excuse me. And I want you to remember this PJV2 location, all right?
Okay.
The next location, 500 Northside Drive Southwest. How many miles per hour?
90.
And what time is that?
10:03.
Is that 2 minutes after the car is at the, or the ankle monitor's at the PJV2 location?
A minute.
Excuse
after.
me, a minute after the PJV2 location,
Yes.
right? I want to show you 397 VVF.
Yes. Your Honor.
I don't know what the, Mr. Sharp's gonna have to tell you why he objected. I had already asked the witness the question about the 90 miles per hour. So that question was done. My next question, I asked her to read the location of PJV2. That's it, what was on the spreadsheet. Then that is when Mr. Sharp objected. So that is the objection that's on the floor. At this point, I've asked her to read PJV2.
Well, she is reading off of an ankle monitor report from the ankle monitor company. To the extent that she reads off of it, that's not really my issue. It's when she starts to interpret the data. She doesn't work for that company. I don't know, for instance, the PGV2, whatever, PJV2, I don't expect to hear her testify or what that means, because she's not the ankle monitor person. The ankle monitor person would have been the person to ask about those things. So I don't get.
What is VJV2?
So the next thing that I was going to show her, which was already admitted, is the picture of PJV2, which is a location that's already in evidence.
But how does she? Okay, so
What you were going to ask her to read.
Yes. So this is the spreadsheet, Your Honor.
Okay.
On here, which I had her read earlier on the spreadsheet, the column has the name, column D has the date and time, column E and F is longitude and latitude, and column G is a location. So before the objection, I believe she was reading, or she had read at March 14th, 2022 at 10:02 p.m., the location PJV2 plus VR, Atlanta, Georgia. That is what my question entailed. And that was the
Okay, and
objection.
she read that?
She
Or
read,
is- Okay, she read PJV2 plus VR, Atlanta, Georgia?
I believe that. if
Or
the
is that when
objection-
the objection came?
That might have been when the objection came.
Okay, and then what?
And I was just going to have her read the date and time of that location. Then I was going to show her what has been admitted already as already admitted as 397 VVF.
That plots that location
Correct.
by the ankle monitor company? Or
No,
by
they-
whom?
We showed the ankle monitor company that picture as it correlated to this location here. So we printed out Google images of these locations, PJV2, 464 Windsor, which is what I just showed her previously.
By the latitude and longitude,
Yes.
somebody plotted latitude and longitude
I don't,
on a map
No, we
to get
pulled
that
up-
location?
No. We pulled up the map. We went into Google and we put PJV2 plus VR. We just Googled it. And we pulled up the location.
so essentially they want someone who doesn't work for the ankle monitor. And mind you, the ankle monitor company person is already here. They want someone who doesn't work for the ankle monitor company to take something that's on the ankle monitor company's Excel sheet and then compare it to a Google printout that the prosecutors
You're right.
printed out, and
That is already in evidence?
That's
You're right.
already in
It's in evidence. It's not, we're not admitting it through her. It's in evidence. The ankle monitor witness introduced it. He
Okay.
introduced it along with the record
Mm-hmm.
of the pictures. And so
Okay.
at this point, when Mr. Shard has
Okay, and
challenged.
then what? So you'll then say, and here's this other piece of evidence that is a plot of PJV2 plus VR.
Is that the location at the light that for the surveillance video that we just observed? Because all of
Okay.
this is in this is all in response to Mr. Shard's cross-examination about what occurred at the light.
Can you put that back up again, please? The thing that was just up. And from this, you are going to have her extrapolate that because at 10:02, his ankle monitor showed him at that location, then what? Because you came up here and were saying this is going to be able to show that the timeline is accurate across all the different devices. How is it going to do
So
that?
the challenge that Mr. Shard made is that the 9:59 phone calls, this started with the phone call at 9:59, which is the wiretap phone call. Mr. Shard asked Investigator Viverito, are you able to know if that is the accurate time?
Uh-huh.
Because of that line of cross-examination, we are now showing Investigator Viverito other admitted evidence that shows a correlation to that 59 time. So when you look at this chart, before we get to the 10:02, which is at PJV2, at 9:59, the
Please
ankle.
put that exhibit back up. Or hand it to me. I'm happy to have a paper copy of it. So now we're talking about 9:59 and not 10:02.
You're right, we're showing Mr. Shard started off at 9:59. Then if you can recall, he went through the entirety of the surveillance video at the FedEx.
Uh-huh.
So that's after 9:59. So what we are showing is other evidence that
he does not dispute that he was at the light
he disputes
at the same time as Mr. Drinks was.
Your Honor, he disputes that Mr. Stillwell is the person who was shooting. He disputes that the call at 9:59 was a call to get on FaceTime to shoot Mr. Drinks. We are saying that that call, that FaceTime call, is a call where they said we are getting ready to go shoot the ops. That's why they get on FaceTime. So he is challenging all of that, Your Honor. So what we are showing is at 9:59, if you look here on the ankle monitor, he's at 464 Windsor Street. That is the BP gas station. He then a minute
9:59 is accurate.
here's,
And lined up to, I mean, I don't see how you can establish that 9:59, according to the ankle monitor company, is, spot on to the second. 9:59, according to the wiretap.
But we're saying that it's accurate time, Your Honor, because he's at 464 Windsor, which is where, if you look at the BP gas station video footage, that is when all the cars begin to pull off from the surveillance video at the BP gas station.
But there is no cross-reference to the wiretap, which is the point. That is my only point, is 9:59 on the wiretap. We don't know when it is on the rest of these devices, and this information does not give us, or other surveillance systems.
Agreed.
And
Do you
this-
have him on the video at the BP station talking on the phone and going like this?
We have the wiretap that has him, we believe, the phone plot.
I know you believe it. Do you have evidence to establish it?
Our evidence is
that-
circumstantial evidence that he is at the gas station. Do you mean, do we have direct evidence? No, Your
No, do
Honor.
you have evidence that the 959 that you want is the same 959 on all of the different things that recorded time in video?
That is why we're showing this, Your Honor, because we're trying to show circumstantially that all these times are.
How
together.
are you showing circumstantially that it lines up?
Your Honor, because when we look at the ankle monitor information, he is at the 464 Windsor at 9:59. The call comes in at 9:59. The BP gas station surveillance video has 9:59. So we are showing that all of these things coexist. So the time could not just be off because all of the time are at approximately 9.
That's if he got the call when he was still at the gas station.
Your Honor,
The fact that they all at some point say 9:59 doesn't establish anything if you don't have a video that shows him talking on the phone at 9:59 so that you can go, aha, see, the video lines up with the ankle monitor that says 464 Windsor Street. Otherwise, it's just what you want it to say, but it doesn't actually, even circumstantially, establish that. You can argue it, but you can't have a witness say, yep, this says 9:59, so that means
but we
That's
didn't
when that-
ask her to say that, Your Honor. That we never asked Investigator
But-
Viverito to
but-
say that. We asked
I
her
know,
what
but
time
you
is she.
were telling me that's what you were
No,
leading up to having her say.
No, it's not, Your Honor. What I said I would never have her say, is he exactly on the phone at that time? Because he's in a tinted car, so we don't know. What we know is from the wiretap that at 9:59, there's a phone call. That's what we know.
That
So I
at
can never-
9:59, according to however the wiretap clock was running.
Correct. Your Honor.
Yes,
And that's
in
what
order-
nobody
come out.
disputes that.
Your Honor, we've stopped talking about
Ms. Hilton, you
9:59.
came up here and said, I'm asking these questions so that I can establish that the timeline lines up for everything.
Yes, Your Honor, the timeline lines up. So
Okay.
at this point, I can show that all of these different devices are around approximately the same time.
I don't think anybody disputes even that it's
But-
approximately the same time.
Mr. Shard does. Okay.
You can have her, it's in evidence. You can have her read something, but you cannot have her say, yeah, that means all of these times lined up. Or
I
that
never was
means
gonna have-
9:59 here and 9:59 on the wiretap were the same thing.
We never had her. We were finished with the 9:59, Your Honor. The only thing I had just asked her was about PJV2 when he objected. We were finished with 9:59 about 5 questions ago. So the only thing that Mr. Shard objected to at this time was that she was reading PJV2.
No,
That's
that
what the
she was
objection-
about to interpret.
She was not, and that's the thing. That
Okay,
was-
well, great. She's not going to.
Okay, well,
and that wasn't the state's intention.
Okay,
don't
then
know
I have
where-
no idea why you think any of this is going to establish that all of the times lined up, but
I'm going to object on relevance grounds at this point because I don't know where we're going, but it seems that they were trying to establish something. They said they're done establishing that, and Investigator Viverito is still interpreting ankle monitor data. So I'm going to object to relevance in 403.
Your Honor, as I stated earlier, Mr. Shard has challenged what occurred at the light.
I
His-
know.
So at this point, we're just showing, based on admitted evidence, what occurred at the light, Your Honor. That's all.
Can I ask a question? Why is it improper or not relevant? So if there has been questions and testimony about whether the times for everything sync up, I think has been Mr. Sharp's, his argument the entire time. Well, in the screenshot that was admitted to Detective Hogan and
Okay, I didn't rule that it wasn't relevant. What we discussed up here at the bench was that it's not within the scope of redirect, which is when Ms. Hilton said, oh, yes, it is, because I'm going to be establishing that all of the times line up.
But on cross, he disputed that the 959 from wiretap was anywhere close or could be related to the 959 anywhere else.
Was established as being the same 959, and I have heard nothing that, maybe you could tell me how you can establish that.
So at 9:59, when he makes the FaceTime or the call, he is at 464 Windsor Street. Okay, so then you go to your next step.
No, that is, how do we know that he's at 464 Windsor Street?
Says it.
Because some other item of evidence says it, and we don't know that they're all running on the same clock.
That's what we're trying to show you it is, because at 9:59, if everyone would just wait, and we'll get to the big ta-da. So at 9:59 on the wiretap thing, it says 464 Windsor Street. On the ankle monitor, on a separate device, at 9:59, Mr. Jackson is at 464 Windsor Street. That correlates, they're in the exact same place at the exact same time. At 10:02, it shows that he's at PJVR2, whatever. That's the intersection of I-20 and the light. And then at 10:02 on the FedEx thing, and it says 10:02:17. So it's the exact same thing. It's to show that all the times line up. All this questioning that the times are not accurate, that the times don't sync up. We're proving that they actually do sync up, which is what he challenged Investigator Viverito about this 9:59, and she's just making it up, and all the evidence is being presented as how she wants it to. And now we have physical evidence from different videos that show they actually all do sync up, that they're all running on the same, time width or band, whatever.
I think you can argue that. I don't think that is established. But if you want to have her say, but Ms. Hilton says you've already left 9:59 anyway. So I'm still at a loss as to where we are. But we'll just get her back in and.
I have a motion before the jury comes out, you wait for back in, because unfortunately, it's my job to further tax the patients in court.
What's that?
Yeah, I have a motion to strike the testimony of Investigator Viverito as well as any evidence that came under her. And the reason I make this motion, Your Honor, is yesterday it came up that she had not been, that she had been following the case. The court asked me to not
No,
pursue
it
that.
did
I'm not.
Come up that she had been following the case. It came up that she knew that somebody had mentioned her on Twitter.
Okay, and your opinion would have been different if she was following the case? Because
No, if you know that she was following the case, that doesn't exclude her as a witness. You can let the jury know that.
Okay, because
You can ask her that.
I can ask her about her following the case?
Sure, and we'll see what she says.
Okay,
And if that's so, then it still doesn't exclude her testimony. It just lets the jury know, well, she may know some of this other stuff from listening to some other witness.
okay, because what I would like to get into, and we may as well bring it up now before the jury is here, is that she got into an altercation out in the hallway with Kayla Bumpus.
Why
where-
is that relevant to the guilt or innocence? of
I'm
these
about to go there, Your Honor.
Okay.
Just let me finish a second. She got into it because she was watching Kayla Bumpus's YouTube feed about this case. And Kayla Bumpus apparently called her.
Okay, you may get into whether she has been tracking this case.
Mhm.
You may not get into whether she got into a dispute with somebody
gets into
about
her-
their posts.
It gets into her bias against these defendants, Your Honor. It goes directly to it.
What are you proposing to ask?
I'm proposing to ask if she told Kayla Bumpus in the hallway that that was the last time she was going to call her a hoe. It goes direct.
I'm sorry, the last time who was going
That
to
Kayla, sorry for the pronouns, that Kayla Bumpus was going to call Investigator Viverito
We need to
a
get
hoe.
into who it was, or just that somebody,
I think we need to get into who it
Why?
was.
why?
Because she's married to Mr. Jackson.
Well, was she at the time? Is this for real, y'all?
Yeah,
None of this is relevant.
well, it does.
None of this is relevant. Whatever is happening between Ms. Bumpus, Mr. Jackson, has nothing to do with the guilt or innocence.
If she is-
Unfortunately, the bias of a witness, well, fortunately, or I strike that. It is not fortunate or unfortunate, except for the fact that it is dragging this case on even longer. But a witness's bias towards a party may always be shown.
If she isn't, if she
Don't
isn't,
talk at the same time.
Caleb Bumpus is not a party to this incident. Caleb.
Yes, but if she's married to one of the parties, then that might qualify.
If I
Here.
just maybe concur, I don't know, I'm not the proponent of this evidence. I'm hearing Mr. Weinstein out, but my silence should not be viewed as acquiescence that I believe this should be admitted. I need to hear what Mr. Weinstein's saying because I may have an objection myself.
what I'm saying is that if there is a relationship between Ms. Bumpus and the defendant, then Investigator Viverito's bias against that.
Against
someone-
being called a bad name?
No, if she is in an altercation with someone that's in a relationship with the defendant, I think, and especially if it is a threat, because
How is that a threat?
that's the last time you're going to call me a hoe. I mean, I've had clients arrested for less.
You may ask.
Thank you, Your
Yeah,
Honor.
no, I'm not finished with my sentence. You may ask if she is following the case and has been following the case in any kind of manner. But it's really only relevant if she listened to the testimony of a witness. So you could ask that. But if she's just looking at, and I don't even know if she was looking at, maybe somebody told her. So why don't we get her in here and find all of that out outside the presence of the jury before we go into something that ends up being a bunch of nothing?
Well, that's why I wanted to bring it up when the jury wasn't here, Your Honor.
So can we also bring up before we go into the side searches, the fact that Ms. Bumpus, Representative Copeland, we're about to open up.
Yeah, I mean, I don't think saying who this is before we find out anything, I mean, do we know whether, we don't even know whether she's actually married to him or if she was married to him at the time, or if Miss Viverito knows that, or if it was because of any kind of bias against Mr. Stillwell, or just that she doesn't like being called that name.
Well, and no one would, Your Honor, obviously. But if she is in an altercation with someone in a
What do you
relationship,
mean by altercation?
a verbal altercation,
Okay. I mean,
you know,
a
if there's-
verbal, that's
if
the
there- I
last
don't-
time you're going to call me that?
excuse me, I'm sorry.
That's the last time you're going to call me that? That's not exactly an altercation. Is that,
Okay.
is that all you've got?
That's all I have.
Okay, that's it. I think that this is 403 material.
There we go. One for the stick.
Hoisted on my own petard, Your Honor.
Correct. All right, let's get the witness back in and the jury back in.
Thank you, Your Honor. I'm going to publish now 397 VVF. And looking at 397 VVF, do you see that same PJV2 plus VR location that you saw on the spreadsheet?
I do.
Okay. And are you able to tell where that intersection is?
I am.
Where is that?
At Windsor, looks like just north of Rawson or at Rawson.
Now, on cross, do you recall when Mr. Shard asked you about the handgun that was on the table at 2830 Waters Road?
I do.
And he asked you about three types of guns: Springfield, Sig Sauer, and Smith and Wessons.
Yes,
Right. First, let me ask you: do you know if a Springfield makes a 40 caliber weapon?
they do.
Do you know if a Sig Sauer makes a 40 caliber weapon?
They do.
And do you know if a Smith and Wesson makes a 40 caliber weapon?
They do.
Permission to approach, Your Honor?
You may.
I'm going to show you what's been marked as Safety Exhibit 531 VV, 532 VV, and 533 VV for demonstrative purposes only. Tell me if you recognize those types of weapons: a 531, 532, and 533 VV.
One is a Springfield XD firearm, one's a 6 Sauer P229, and one's a Smith and Wesson.
And looking at those three weapons, are they able to illustrate what you were talking about, the distinction between the Glock 27 as well as these other types of weapons?
Yes,
Okay. Your Honor, this time the state would like to admit 531 VV, 532 VV, and 533 VV for demonstrative purposes.
Admitted.
Permission to publish?
You may.
Looking at 531 VV, are you able to tell the jury about the distinction you were making between the grip of, say, a Springfield versus the Glock that you were talking about on the table at 2830 Waters Road?
yes, it would be along the bottom part of the grip.
Say it one more time.
Along the bottom part of the grip. Should be right. You might have to scroll it up for the jury. a little
Or
bit.
can you use the one at the,
Or, I'm sorry, right here. This is straight across, like with a little bit of a piece that comes down towards the back.
and is that distinguishable from what you were describing with the Glock?
Yes,
All right. Now looking at 532 VV,
again, the same thing. You'll see there's something that comes down in the back, but otherwise it's higher up towards the front.
and you had to speak into the mic for me because I can't hear you.
Sorry, it's lower towards the back, higher up towards the front. So it kind of a part that dips down in the back and then comes up.
And for 533, I'm sorry, what kind of gun is this 532 VV
I believe that's the Springfield XD.
or 532?
Or sorry, which one? 532? It's a 6 Sauer P229.
Okay. And then 533 VV.
You'll see again here, there's a piece in the back, but then once you get to the front, it's just straight across.
And then what type of weapon is 533 VV?
That would be the Smith and Wesson. I'm sorry, the 530. Yeah, the Smith and Wesson.
Now I want to go to, and Mr. Kokomo, if you can help me out, please. DS57A, DS57C, and DS58A. And while that's being pulled up, Mr. Shard, they asked you whether or not there were people, I guess, not necessarily looking for Mr. Stillwell, but that there'd be some concerns for his safety because of the Tierra Jones killing. Do you remember a line of questioning regarding Tierra Jones?
Yes, several years ago, that was an incident.
When was the Tierra Jones killing?
It was several years ago. I can't remember the exact date.
Do you remember the year?
Not offhand. All right.
Now, looking at, I believe this is DS 57A. Is this the communication between Mr. Stillwell and Miss Alexander regarding the shooting at McDaniel? Excuse me,
It is.
at I-20 and McDaniel.
It is.
Do you see any response from Mr. Stillwell in the text message that's, dang, babe, I was just at that intersection. Or man, glad it wasn't me. I just missed being at that location.
I do not.
Do you see any text messages to Miss Alexander that says, man, I was just at that BP gas station a little while ago. That's up the street from there.
I don't.
I want to go to DS 58. And is that the communication between Mr. Stillwell and his grandma?
It is.
Right. Do you see where she says, hope you are not near Windsor Street shooting on the news? And says, answer me, please.
Yes.
Does he say anything to his grandma? I'm like, know what, grandma? I was over there earlier, but it's not me.
He does not.
Now, we talked about searching for on Fox 5. Do you remember talking about the searches on Fox 5?
Yes.
Okay. Did you see any searches on March 14th when both his grandmother and Taisha were asking him about whether or not he was around that location or if he heard about it? Did you see any searches for the shooting on that day, on March 14th or in the early morning hours of March 15th?
No.
Are all of the searches on March 17th?
They are.
And is that the day he was ultimately arrested for these charges?
Yes.
Now I want to go to Stacy to the 437 VV, page 2145. April 1st, 2022, from 11 p.m., 11 minutes to 11:20 seconds into that call.
What time's again? I'm sorry.
11 to 11:20. You can pause the clock.
Yeah.
Yeah, that's all it is. Just assume. Hey,
Yeah, I already know. Like when they got down, go to wiping down, doing them got down, them. You know how they gunpowder, forensics, all that shit there.
yeah.
You gonna come back clean. You see what I'm saying? So I ain't tripping on that.
Uh-huh.
Yeah.
during that call, he says, when they talk about that GSR stuff, it's going, when they wipe it down, it's going to come back clean.
Correct.
At any point, he's saying, I don't know why I don't even know what any of this is about.
No.
Does he say to his best friend, I don't even know why they took this?
Yes, Your Honor. Proper commentary, also facts on that.
Sustained.
Does he say to Demekian Grant on this call, I don't even know why they took that car?
No.
Does he say to Demekian earlier in the call, that Miles and Quay, they don't need to worry?
Yes.
Miles and Quay, were they both in a Ford Fusion?
Yes.
Were they in the car that was furthest from Mr. Drinks?
Yes.
Did you hear when Mr. Stillwell told Mr. Garlington, I told them not to talk to the police, don't say nothing? Did you hear what he told Mr. Garlington that?
Yes.
And this entire call is on the contraband phone
Correct.
that can't be monitored,
Correct.
or outside of it being a wiretap, cannot be monitored.
Correct.
LPR readers, what information do you need about a car in order to look for a car on an LPR reader?
A license plate, a tag number.
Do you at least know the make and model of a car?
Yes, Your Honor, leading.
Overruled.
You can try by make and model, but it's not very accurate sometimes, especially at night.
With the two cars that we saw in the FedEx surveillance video, were you able to see any license plate information on either of those two cars in the FedEx video?
I was not.
And at that FedEx video, is that where we see the Audi and the Ford Fusion run the red light?
Yes.
Court's indulgence. No further questions.
All right, recross.
Thank you, Your Honor. May it please the court. Investigator Viverito, good afternoon.
Afternoon.
So you were just asked about LPR readers, and I think the context is figuring out the car that did the U-turn and the car that sped up behind Mr. Stillwell.
Okay.
And you said you need a license plate and that you can't see the license plate from that video.
Or if you have it, sometimes a make and model search might work, but at night, in my experience, it's not very accurate.
Well, are you aware that it was in fact a make and model search that night that revealed the license plate of the white Audi and the white Ford Fusion?
No.
Okay. That Detective Ender, I believe her name is, did? Okay. So the bottom line is LPR search by make and model, it's never going to work if you don't try, is it?
No, but if you're saying she did it for the
Okay, y'all. Let me tell y'all what happened.
So what's the license?
Y'all.
Well, I was gonna continue. Like over the summer, I've been working in
Nah, I'm
investigation.
stepping outside. I gotta get some fresh
Lady
air.
looking for a very particular two cars in the city. I probably searched every LPR in the city by make and model. And at night, you may put white Nissan, you may put white this, white that, and I'm getting back white
Y'all,
Tesla. When I look at the license plate and pull
I
up the
don't.
results, they're not correct.
And I appreciate that anecdotal story about what you've been doing this summer, but the fact is, that night, make and model was used to.
They know my Abate say I married Shannon. The judge
And
say we don't know if it's true. Doug say this.
Right.
I have
Mechanics.
spoken to neither.
it was nighttime on March 14th, correct?
Right. But depending on what
I was
LPR
in
you
the
call
court.
that hit, that location on Windsor right
Y'all,
there, I don't know if there's one right there that would have caught it
I'm
correct.
definitely not
Okay,
saying
well, what
nothing.
LPRs did the part of the
I'm
defense
definitely
receive
not saying
from
nothing right
Stillwell
this
that has
second.
not been tested for
Y'all
firearms?
gonna have to wait till
What LPRs did that?
WTF Wednesday
You'd have to ask
because
Detective Hogan.
what?
Okay, you keep saying ask Detective Hogan. One minute you're on the side of Windsor Street trying to find homeless people as part of this case,
Correct.
and the next minute you don't know anything about the case and it's ask Detective Hogan.
That's not what I said.
Okay. Well, I want to know, do you know if any LPRs were run on the make and model of any cars besides the white Audi, the Ford Fusion, and the red Versa? Do you know if any other LPRs were run or even attempted to be run?
First, I wasn't in charge of running the LPRs for the case.
Okay.
And if they were running it by make and model, that maybe they saw, if you have a make and model, it's much easier than just say not having one that you're looking for.
You talked about the phone conversation between Mr. Stillwell and Mr. Garlington about he never told Mr. Garlington, I don't know why I'm being arrested or something to that effect, or I don't
Correct.
understand. Okay, when people are arrested, you've arrested people before, right?
Correct?
Okay, and you typically tell them what the charges are. You give them that courtesy.
Yes, of course.
And you tell them what you're arresting them for.
Of course.
Okay, they don't have to agree with you, but you do inform them of that.
Correct.
Okay, so are you saying that Mr. Garlington is the first person that Mr. Stillwell would have talked to after being arrested on that jail call or that phone conversation? Is that what you're saying?
No, he'd been in custody for a minute at that point.
Okay, and you would agree that there's probably been significant ability for the people that arrested him, other people involved with the case, to inform him what his charges are and generally what he's accused of.
I don't think that's what Ms. Hilton meant. That's not how I took the question for me.
Okay, cool. We pulled out this mapping information for the call on March 15th at 2 a.m.
Correct.
And it showed that, remember that radius? And it was
Correct.
Mechanicsville.
Correct.
Mechanicsville is in fact in the city of Atlanta, correct?
Correct.
It's in the city.
Correct.
And finally, just one other thing I wanted to ask you about. Miss Knight, could you do me a huge favor? I think it's 471 BB. Could you publish? Did I get the number right? Oh, okay. This is 471 VV, and that is a picture of Mr. Nichols, correct?
Correct.
And on it says, on the picture on the right says, what you saying, I run with cold-blooded killers, bloodied killers.
Correct.
Okay. Now, I'm not an Instagram person.
Okay.
Those words, are those words that Mr. Nichols typed into this photo?
No, I stated that yesterday.
Okay, well, we're going to go through the whole process.
Okay.
today. So these words are when you pick a song such as Young Boy Never Broke Again, Villain, and someone clicks on the post, the music plays, correct?
Yes,
Okay, and as the music plays, lyrics come up.
correct. You select a portion of the song that you would like to play.
Well, that's not entirely true. Instagram suggests a
Sugge-
portion.
It's like between a 10 and 30-second portion.
Yeah, and
that
Instagram suggests.
you can agree with it or you can modify it.
Right, but Instagram suggests.
Correct.
Okay, so if I'm posting something and I want Young Boy Never Broke Again, Villain, I'm going to post, I'm going to say that's the song I want, and Instagram makes the suggestion.
Correct.
Okay. And now I want to go to the video. Miss Knight, can you help me out with the VVA? Thank you, Miss Knight. 471 VVA. And Miss Knight's about to publish it. What I would like to do, and I know we've seen it already, but if you would indulge me, tell me when the screenshot that you took and provided in Discovery for 471 VV, tell me when that comes up.
I've been here to it all. Come on, I won't fuck with you often. Baby, I ain't got no reason. I think I need you. Stay down. I done came back from the dance, wipe off the leaves. I don't want any of these lessons off the street. I fucked her the first night and then I never called again. Next time them shout to see me, I was riding with a friend.
I was gonna have my page private, but you know what, man? I don't give a fuck. But y'all pussy. Don't even come from no fake page. Come from your real page. I don't get no fuck, man. Come on, man. Hey, it ain't private. It ain't private.
I'm a bloody man, I don't feel shame for all them niggas dying. Holding on to my name when they claim, and through the night I'm crying. These bitches lying, let's face the fact. Them bullets flying, let's talk about that. Couldn't grab my strap, bye shot back. I feel the pain of the end. When I did my time, I ain't feeling nothing, it was fun.
And this is what they want me to do in Instead Heights. I might die. Never getting on another fucking roller coaster day in my life.
Oh, you talking about? I don't want to talk. Won't speak on that, I'm too official. I heard your niggas let them choppers off. Strictly about beef. I go to war with any nigga. I heard them say that they won't smoke with us. Ain't got no better nigga, ain't gon' fuck with us. So what you saying is up. I step on any nigga. Name a block ain't hit, name a hoe ain't hit. Name a nigga don't try this shit to survive this shit. Every nigga don't try this shit, don't die this shit.
I can't tell you, it might have gone too fast. I'm not sure.
Okay. Could you go to 140 and just 138? Okay, right there, and just start playing again.
Won't talk, won't speak on that, I'm too official. I heard your niggas let them choppers off. Strictly about beef. I go to war with any nigga. I heard them say that they won't smoke with us. Ain't got no better nigga, ain't gon' fuck with us. So what you saying is?
So, Miss Knight, if you could just rewind it, and it's very brief, about 1 second. A little bit further. I appreciate it. Investigator Viverito, when you saw this story by Mr. Nichols, you had to scour this story to find the spot on this post where it had those lyrics, didn't you?
Well, no, I turned over in Discovery the video in its entirety because I felt all of it was pretty damaging and consistent with the case. But it's my understanding that we had to condense the social media. So that was the screenshot that was turned over in lieu of the video.
I'm going to ask that question again. To get that screenshot, you had to parse this to a millisecond to get those words up on the screen.
Or I just took a screenshot and it happened to be that one and we kept it.
Oh, it just happened to be that one.
There are other things that that probably would have been better to keep
Okay.
that weren't kept.
So, so you just happened to screenshot. Now, you would agree that in this video, there's Mr. Nichols and these lyrics are being shown on the screen as music is being played.
Yes.
And you would agree that many of the lyrics as the song is being played are up on the screen and easy to read.
Correct.
Okay. Right before the lyrics become easy to read, there is a split second, a millisecond, that has those lyrics in that picture. 471 VV, isn't that correct?
Correct.
You don't even know if those lyrics were the ones, first of all, you don't know if it was just suggested by Instagram or actually chosen by Mr. Nichols, right?
The song was chosen by Mr.
Yeah,
Nichols.
of course the song.
Okay.
I'm talking about the lyrics. You don't know if it was Instagram choosing these lyrics because these are the most popular ones in the song and they make a suggestion.
No, but based on the rest of the videos on the post, the theme is murder, bullets, guns, things like that. It fit.
So again, and you don't even know when it's on for that millisecond. Just supposing, hypothetically, if Mr. Nichols did choose the lyrics, you don't even know if that was Instagram just had the last lyrics up and then was getting to the lyrics he chose, which are shown clearly, or if it's something that Instagram just chose. You don't know.
I don't, but he can preview the post before it posts to his account.
Okay. So you have absolutely no evidence that Mr. Nichols intentionally chose those lyrics.
Which is why I included the video in its entirety with the other posts about murder and shooting.
And in preparation of this case, you scoured this video and paused it at that exact millisecond when it had those lyrics.
Did not. I took a screenshot.
Okay, took a screenshot. I'm sorry. At that exact millisecond where it had those lyrics that are in
I-
471 V.
I probably took several trying to catch all the lyrics, and that was probably when we had to condense evidence. That's one that was chosen.
How many different screenshots did you take?
I have no idea.
Well,
We're talking
can you
about.
just tell me from your report?
I can't. You can look at my folder that was served to Discovery and tell me.
All right, thank you.
You're welcome.
Ms. Weinstein, anything? Okay.
Good afternoon, Investigator Viverito.
Good afternoon.
So you mentioned that Mr. Kendrick's phone was seized at the time that he was arrested on May 9th, 2022, correct?
It was.
And his phone was extracted.
It was.
Did you review that extraction?
I did.
And if you reviewed that extraction, did you see?
Do
that
y'all
he
want to
had
do
been spending several
WTF
months in LA and
Tuesday?
only returned to Atlanta within a day or two of the day he was arrested?
I did.
Y'all,
Did you also see other location data within that phone?
Absolutely.
Okay. And in that location data,
y'all, I'm
again,
outside. I
he's
had to
been
come
spending the
outside.
bulk of his time in California, correct?
Correct.
All right. Did you look through all the photographs on that phone?
Y'all,
Looked through a
what's
good bit of them, yes.
The two photographs that were shown in court this afternoon, are those the only two photographs of interest that you believe were in the phone?
No, it's raining.
No, there was probably a few.
Okay. Did you find any evidence on that phone that Mr. Kendrick was in possession of any firearms?
No.
Okay. Let's briefly return to the Richard Mill watch.
Yes, sure. Sure.
I understand the eye roll. During the seizure that day, and I'm looking at a property report.
Sure.
During the seizure that day, you, and when I say you, I mean APD, can I say under your supervision? Is that accurate?
I didn't work for APD at that time, so I
Well,
couldn't.
Okay, then let's just say APD. Y'all see, APD seized, APD seized a necklace and a pendant from a bedroom, correct?
I guess I'd have to look at the report. I don't have it in front of me.
Okay, well, you were involved in this. They seized a blue box of jewelry, correct?
Correct, in a red box.
And a red box of jewelry. They seized jewelry that was on Martinez Arnold.
I believe so.
They seized a Chevy Corvette,
Yes.
a Dodge Durango,
Yes.
a Mercedes-Benz AMG,
Yes.
a Mercedes-Benz GLS class,
Yes.
a Porsche 911,
Yes.
a Jeep Grand Cherokee,
Yes.
a pink Lamborghini,
Yes.
another Mercedes-Benz aluminum silver,
Yes.
about jewelry that was located in a Mercedes AMG.
Yes.
And they even seized a ring found on Jeffrey Williams' hand, correct?
I'd have to see which one was on his hand. I didn't have any contact with Mr. Williams when he was arrested.
Okay. So despite seizing all of that, you left behind the Richard Mill watch, pink with a white ceramic case.
Again, Mr. Weinstein, as it's being inventoried, the jewelry is being looked at. I use photographed. The jewelry is being put on this thing. If you watch the video, and it's placed on the shelf, and nobody messes with it again.
So was that a yes?
Yes.
Okay, thank you. I have no further questions.
Thank you.
All right. Thank you, Detective. You are
Thank you, Your Honor.
excused. Do you have any more witnesses?
I know, but before we do, we just need to, can we have about 5 minutes, Your Honor? I just want to confirm that we have in evidence.
To make sure that everything's in evidence, sure. We'll take a short break.
I know, right? I'm standing outside though because I'm standing outside because it was hot inside.
All right. While you are making sure that all of your stuff is in evidence, I need to ask each defendant some questions about to make sure that they understand their right to testify or not. All right, let's be back at 4:45.
Oh yeah. I gotta go to the bank right quick. Okay. Hold on, y'all. I gotta make some calls. I'll be back.
will both be examined by your attorney and cross-examined by one of the prosecutors. Do you understand that? All right. And do either of you need any more time to talk with your lawyers about your decision whether to testify? All right. Mr. Kendrick, do you personally want to testify or not? Okay. Mr. Stillwell, do you personally want to testify or not? All right. I find that each of these defendants has made a decision whether or not to testify with an understanding of his rights. All right. All right, we need to do anything else before we get the jury out, and I'll ask if you rest. And then have y'all made a decision about whether y'all going to present evidence? Okay, you want to let me know, or you want to be dramatic about it? Okay. All right. All right, then I'll get them out. We'll close the evidence. I'll let them go for today and tomorrow. Have them come back on Thursday. And tomorrow, I mean, we can start the charge conference. And, oh, forgot something. There'll probably be a motion, I suspect. Okay. All right. Forgot about that. Okay. So I guess technically you need to rest before that motion. So I'm going to have to bring them in, then excuse them again. Okay.
Your Honor,
Yes.
I understand that we're trying to keep things moving. I'm going to ask if Your Honor would consider giving us the afternoon and evening to look at the directed verdict motion. I know that you've suggested we need to be doing that, but there's only 24 hours in a day, and I think it would probably be more fruitful if all of us had an opportunity to review kind of what's come in, and so we can sit down and have an educated discussion.
Sure,
about
that's
it.
fine.
All right,
So
thank you.
tomorrow we'll gather together. You'll present whatever motions you have,
Thank you, Your Honor.
whatever response there is. I'll have to consider all of that. But I would also like to do the rest of the charge conference, the RICO part of the charge conference.
Can we have a further discussion with that once we excuse?
Yep, sure. Okay. What are you, do you need?
I was just thinking procedurally, what happened? We rest, then we have, we bring them.
We rest. I let them go for the day. All right, Ms. Hilton, does the state have any further evidence?
No, Your Honor, the state of Georgia rests.
All right, thank you. Okay, ladies and gentlemen, considering the hour, I think that I'm going to let y'all go for the day. And then actually tomorrow, we will all have matters to take up outside of your presence. That's been kind of a common theme in this trial, and it happens in every trial, I promise. So y'all will have the day off tomorrow, and we'll see you back Thursday at 9 a.m. And just let me remind you all of the instructions that have been applicable to you for the entirety of this trial remain applicable right now. Don't try to find out any kind of information about this case from any source outside the confines of this courtroom. Don't talk to anybody about this case. Don't let anybody talk to you about this case or anybody involved in it. Don't try to do any research about the case. Don't ask anybody hypothetical questions about the case, and we'll see y'all on Thursday. Thank you. Okay, so what else did we want to discuss?
When we were, Your Honor, when we were talking about the RICO jury instructions, I guess what I'm trying to figure out, I understand that we have certain jury instructions, preliminary, we both submitted preliminary jury instructions. And I know that we have certain ones on that document that we're all sharing. I'm just trying to make sure, are there any other proposed instructions from the state that I need to be aware of to prepare for argument? Because I don't want it to be sprung at the last minute.
I mean, I haven't gotten any. Are there going to be any more forthcoming? I've been trying to put some together from various things that I've culled from different RICO cases, and that was pretty rough when I sent it to y'all yesterday. I've worked on it a little bit more today. So I'll send y'all an updated draft, which, Ms. Percival, let me send that to you right now. So what this is now, it will look somewhat familiar, but it's in a little bit more polished form. So the first 4 pages are what I've put together, and then the last page and a half probably is lifted, some of the language lifted from the APS. RICO, not APS Atlanta Police, APS Atlanta Public Schools cheating trial. I have looked at some other trials too and tried to pull some language from that. But if there's something else, I haven't gotten it yet. Mr. Floyd, are you going to be providing us with any suggested jury instructions on RICO and or a possible verdict form with regard to RICO, which would be really nice?
Those are separate but related questions, Your Honor. So to answer the first one, we haven't sent anybody any additional ones. We've looked at yours. They've been kind of evolving. But I don't have very much complaint about them. They're largely drawn from APS, and I wrote those. So I'm not, it's only just a matter of whether there's anything in between.
Those aren't actually drawn from APS. I didn't look at the APS stuff until this afternoon, but okay, you can take credit for it.
Well, I thought that's what you said. I'll tell you that they are, if they're not drawn from APS, they're drawn from cases that use a version of the APS charges.
Okay.
There might be an intermediate generation, but they.
Anyway, I hear you saying you think they're pretty good.
You heard me say, I think they're pretty good.
Okay.
And I mean, I can't at this stage, because we're just starting this process.
Sure.
I can't foreclose that depending on what you decide to do with one charge, we might suggest that another needs to be supplemented or we add something.
Sure.
But I think.
You don't have any whole scale additions that you think need. We'll just hash through it. Okay.
I do not. And I think there's one issue that has to be resolved. I mean, I only have 2 charges submitted by Mr. Kendrick.
Yeah.
I don't have any charges submitted by Mr. Stillwell. I'm Rico.
They're working together on it.
We're working together.
Okay, that's what, I'm just making sure I'm accounting for everybody here. I understood they were from the defense. They had the name Kendrick on them, so that's why I made that specification.
Thank you.
But I'm gonna surprise you. We disagree with them. I'll explain why. One is a short explanation, one is a longer explanation. You have statute of limitations. And then
Oh,
you
yeah, I
have
already
evidence.
told him he's totally wrong on half of that.
Okay,
You missed that part. but-
Okay.
Blunt, Your Honor, it's fine.
All right, it's the opposite. The rule is the opposite of that.
All right, well, we'll get into the nitty gritty tomorrow if that's okay with everybody.
Sure. And the other one, which is how you instruct the jury about overt acts and what conclusions they need to reach, that feeds into the jury form. And I've done a good bit of research and I have some things to say about that.
Well, if you have anything for me to consider sort of in the interim, because you probably are not going to be, I mean, you might be working on the directed verdict motion and response, but if you're not, and if you have something that I could be considering in the interim, go ahead and send it to Ms. Persifield. Because, yeah, I mean, it's a lot more straightforward when you're alleging RICO and not a RICO conspiracy. And so I definitely want to get right what it is that the jury has to find.
Understood. Yeah.
So, yeah.
Yeah, so I mean, I can tell you that what the state submitted is based significantly on EPS, which was also a RICO conspiracy case. It is also based significantly on the jury charges that were submitted in a federal Georgia RICO case based on sex trafficking this year.
Okay.
And also on a case that was tried last year in Brunswick that was a Georgia RICO conspiracy.
All right.
So it's sort of the evolution of that. And I'll address what you want me to address, however you want me to do.
Okay. All right. So if you do have anything more in writing, go ahead and send that now. And that includes a potential verdict form. Just send it to Ms. Persifield. She can send it out. I mean, I think we've got a list of all of the attorneys. So
I don't have anything set to send right
Okay,
now. But
that's
if
fine.
it's tonight or first thing in the morning, our view is the verdict form can be very simple.
interesting.
We would want probably a more detailed.
Tell me more.
Okay, why don't I get into that then, Your Honor? So the question I think that has come up is whether the jury should be asked to decide which acts of racketeering activity the members of the conspiracy agreed would be committed. And there's two approaches to that. One approach, which is usually what defendants suggest, is that there's going to be a very long list of every one of them, and they're going to be asked somehow, did the conspirators, which would really mean any of the conspirators, any two of them, agree this crime would be committed? Because the ultimate objective has to be a substantive violation of the statute. That's the Supreme Court, U.S. Supreme Court said that in Salinas, and I think you've recognized that in things you've said and pleadings that have come along. The other approach is to say, instruct them that they have to agree that the conspiracy contemplated certain types of acts of racketeering activity, and they have to decide whether the conspirators agreed that any of those types would be committed without going to specific ones. So, and usually when I've addressed this issue or something like it, the argument from my opponents is, well, why wouldn't we want to know everything? The answer is you get a case like this where you have almost 200 overt acts. About half of them are also racketeering activity. And that is an opportunity for a lot of confusion, and takes a lot out of the jury. It's a big ask for them, and jurors,
No, we've already asked so much of them.
I suggest we ask not that much more, but that's just me. But the point is that is just not normally how it is done. And this starts out with, and I know we submitted a brief on this earlier, a bench brief, but it starts out with a basic understanding of what conspiracy is. And the crime in conspiracy is the agreement. The crime is not the commission of acts of racketeering activity, because none have to be committed.
It's
for
the
conspiracy
agreement plus
violation.
one overt act.
Exactly. And the function of the overt act is important to understand too, because the overt act doesn't have to be a crime. And the reason is the function of the overt act, which is to show that the conspiracy is in operation. You know, I mean,
Right.
and I realize I may be telling you a couple things that you are very familiar with, but I will be very brief. I mean, common law, no requirement for overt acts at all. There's no constitutional requirement. Federal RICO doesn't require overt acts. The Georgia General Assembly decided to track 1648, which is the general conspiracy statute in 2015 that was added. I'm actually kind of familiar with how that happened by coincidence. And so that's it. We have an overt act requirement. But all that overt act does is show that the conspiracy doesn't exist solely in the minds of the conspirators. It's actually moved into the real world. And there's kind of a fairness issue in that, which isn't required, but many legislatures decide to do it because it gives someone who, I'll just draw the example, you know, there's folks are having a few beers and there's a lot of talk about what ought to be done, and everybody says, yeah, that's great.
Yeah.
Nobody does anything. The next morning, someone sobers up
Charge
and
somebody
says,
with the crime.
hell no. So
Yeah, I'm with
that's how it functions. So this question has not come up under Georgia RICO. This question has come up numerous times under federal RICO.
This question being what?
Does the jury have to decide which acts of racketeering activity the conspirators agreed to commit, or is it sufficient for the jury to decide the types? Okay. And the answer is uniform. Every federal court that has addressed this question has said it is type, it is not specific. And I can give you.
I mean, I think that makes sense, because what is required is they're agreeing to do bad things through a pattern of interrelated racketeering activity.
Yes.
So.
Yeah. And so what we get to, and I mean, just to kind of illustrate it in a case like this, suppose you have members of a gang and they are discussing what they want to do versus their ops. And they say, we hate those guys and we want to kill them. Everybody agrees. Yeah. I mean, wherever they are, we're going to hunt them down. We're going to kill them. If we can get them all, we'll get them all. We'll get as many as we can. Right? Have they agreed to kill a specific individual? You don't know the first person they're going to encounter. You don't know which of the members of the conspiracy will encounter that person first. If they are successful in encountering them, you don't know whether the encounter will be fatal to that individual, whether they'll be wounded, or whether they'll just be assaulted because somebody shot at them and missed. But all of those are acts of violence. All of those are within the scope of the enterprise. And in this case, you have all of those things actually happening in real life. They're not hypothetical. A terrorism analogy would be a group of people who agree to plant bombs. And they say, you know, we need to destroy, I'll put it in Al-Qaeda type references. We're going to destroy the symbols of the great Satan's arrogance. Yes, what are those? His monuments, his hotels, his whatever, okay? We must do this, yes. How far will we go? As many as we can do. They've agreed to make bombs, plant bombs, destroy things, hurt people. We don't know exactly which bomb will get planted, exactly where, if it'll actually go off, whether hundreds of people will be injured or nobody will be injured. But they have agreed to engage in this course of activity that is the violation. It's manifest. In federal law, all they would have to have is that conversation. Georgia law, all they would have to do is have that conversation plus an email, a phone call, or in some cases, as it tends to be, many, many other things.
Mhm.
But that's all it is. And that's why, you know, just for the record, I'll give you a few examples. United States v. Applins, APPLINS, 637 F 3rd 59 at 8081. It's a Second Circuit 2011 case held. The jury was not required to answer special interrogatories as to which specific predicate acts each defendant would commit. U.S. versus Gutierrez.
What, 637F, what?
Sorry.
What's that one?
637 F 3rd 59
Okay.
at 8081. United States versus Gutierrez, GUITERREZ, 963 F 3rd 320 at 328. District Court was asked to issue special verdict form requiring the jury to identify specific racketeering activities each appellant conspired to commit. It declined, affirmed.
Okay, is it reversible error to require the special interrogatory?
I could not say that, no. I don't think it's reversible error.
Okay,
I think, I believe you have some discretion here.
okay.
The question is, how is it best exercised under
Okay.
the circumstances? US v. Cornell, spelled like the school, CORNELL, 780 F 3rd 616 at 625, 4th Circuit 2015. Cornell cataloged the cases. It surveyed the federal cases and said I'm quoting, every circuit to have considered this issue has concluded that for a RICO conspiracy charge, the jury need only be unanimous as to the types of racketeering acts that the defendants agreed to commit.
Okay, and that does seem to make sense to me because, again, we're at the conspiracy stage. We're not at the completed racketeering acts stage necessarily. So, okay.
Yeah.
All right.
I won't belabor the point then.
What else? How about overt acts? I mean, those need to, if there's going to be one needs to be found, at least one needs to be found. That would need to be specified, right? And found unanimously, right?
At least they have to be unanimous that an overt act occurred. Yes. They generally, and I'm looking for, I apologize, I have the language with me. It'll take me 1 second. I have an example, and if I can't find it in 20 seconds, I will send it to you.
Okay.
But the instruction was you must unanimously find that an overt act was committed and you must be unanimous as to which one. It was not, you have to go top to bottom. And I think that is more efficient and just less likely to cause confusion. The overt act,
I would like
something the
that
statute requires, but it doesn't require a great deal of effort. Here, the question was, and I'll show you the case. It was not a RICO case. Unfortunately, lots of cases talk about what the court did, but don't tell you exactly what it said. They don't give you the exact instruction. A case called United States versus Boyle, B-O-Y-L-E, 96 F 3rd, 1444. It is out of the Fifth Circuit. It was, I just want to be clear, it was not a RICO, it was a conspiracy.
Mhm.
The question that was asked was, do you agree unanimously on at least one specific overt act which was committed in furtherance of the conspiracy to commit each of the offenses you checked in question one, because there was more than one conspiracy.
Yeah, I'm not sure how much we can say that's on all fours, though, considering, like you said, it's a conspiracy case and not a RICO case, which I know RICO's not a conspiracy, but we've got a specific overt act requirement in our statute. Do you know of any Georgia case law or case law from a sister state with similar RICO statute that answers this question?
Well, let me tell, I'll take a shot at that in a second, but let me back up because
Okay.
the case I was talking about, I should have said this up front. It was conspiracy to commit obstruction of justice.
Okay.
The federal obstruction statutes don't have their own embedded conspiracy provisions.
Mhm.
So that's a general 18 USC 371 conspiracy, which is almost identical to 1648. So that was under a conspiracy statute that had an overt act requirement, just like ours does.
Okay.
And if you were to match 1648 against 18 USC 371, they're basically the same statute. I think 1648 is drawn from 371.
Okay.
As far as other states addressing this, I have not found anything.
Okay, and so would your suggestion as to how the court ensures that they find one within the statute of limitations just be to include that in the instruction, not only you must unanimously find one and it must be unanimous as to which one it is, you must unanimously find one within whatever that date range is?
They have to find one within 5 years
Yeah,
of the
no, I know.
indictment. That's the test.
But I mean, would you just say like, you must unanimously find one within this date range?
Yes, I mean, you could, well, the instruction that I saw, that's the other one I was going to talk about. And you suggested that you'd already settled that. I didn't hear exactly how it was settled.
Oh,
But the test,
yeah, the other one about like, I can't remember exactly what it said because I've already deleted it from my version, but that anything that wasn't an overt act within that statute didn't even get included, and that's not true. It can be 500 of those as long as one of them is within the statute. They can find however many others they want to outside of the statute.
yeah, and they can go back to the beginning of time
Yeah.
as well. This question was answered in a ruling by
Which
Judge
question
Glanville.
now?
The statute of limitations question.
Yeah, I don't have any question about the statute of limitations
Okay.
question.
All right,
I know that that proposition was incorrect, and
Okay.
I understand what the law is.
all right. And then, okay, so I may have been missing the exact question you asked me.
So
I'm
the
sorry.
question I asked is if I am not having them find, overt acts 1 through 190, do you find this or not?
Right.
Then is the way that I ensure myself that they found an overt act that is within the required 5 years prior to the indictment to just tell them, you need to unanimously find at least one overt act within the date range, and your decision about which one has to be unanimous?
Yes, I think that takes care of it. It actually answers both questions. Those were the only two
Okay.
charges I really had much to say about, and I think that would take care of it neatly.
Okay. All right. Well, again, we'll get into the nitty gritty tomorrow.
Okay. All right.
Okay.
For what it's worth, in Georgia, the closest that I know of this issue coming up was the Dorsey trial. And in that, Judge Becker had initially said she wanted the jury to fill out this form. That was a substantive RICO. And so she would have been listing predicate acts, not overt acts. But that's kind of the same idea, basically. I don't know exactly why. And initially I wasn't successful in changing her mind, but she wanted to do it after they decided guilt or innocence and then bring the jury back. Jury went 3+ days and they came back and
Well,
they,
there are these
were a mess.
federal statutes, or not statutes, I'm sorry, but there's federal case law that seems to suggest that they need to find guilt, and then, and only then, do they need to say what predicate acts they found, which I find to be odd, but
that's mostly, I think, out of the Second Circuit, and
Yeah.
nobody else
Third
has
Circuit,
decided
too.
they like it. I mean, you can
that
find
may have been
many
why,
different
but
ways of
anyway,
handling it,
yeah.
especially if you go back.
very odd, doesn't help the jury at all.
Well, no, and asking the jury to do that if they've been deliberating for a very long time and coming back in and saying, and now you have another homework
I
assignment.
mean, what I want to do is give the jury a logical and correct roadmap as to how do you consider this?
Right.
What are you supposed to think about? What are you supposed to find? If you don't find it, then what happens? You know, I want to give them instructions that actually help them deliberate.
Yeah, yeah. And it's actually, there are federal opinions that say sort of offhandedly, a RICO conspiracy case is a lot easier than a substantive one. I'm not sure everyone agrees with that, but I don't think it's a lot more complicated. It's really, do you have an agreement? Would the agreement have violated the statute if it was consummated? And was there an overt act? And then as to each individual, were they part of that conspiracy or not? And if it's
All right, let me ask you this.
the nuts and bolts.
So there has to be a, determination from the jury, whether it's a violation of subsection A or subsection B, that, they conspired to either participate in the enterprise or acquire money through a pattern of racketeering activity and that somebody committed an overt act to further just the criminal objectives of the conspiracy as alleged in the indictment, or to further the specific pattern of racketeering activity that had been agreed upon?
No, it is not. There's nothing, first, to kind of walk it through, there's nothing in the case law that says it would have to be as specific as the second. And so if I'm just conspiring in an enterprise, if I'm just saying, I hear you guys are the best robbery crew in town, I want to be part of it. And they say, okay, but you have to ante up $1,000, or we have to use your car. Pick anything you want. Give me your cell phone. Lend me $100 till payday. Any of that. As long as it ties to that enterprise, that's sufficient, and that's why the overt act itself doesn't have to be a crime. And part of what happens here is if we pile on additional requirements that aren't in the statute.
Okay, so it's just then to further the criminal objectives of the conspiracy.
Yeah.
And it's the criminal objectives of the conspiracy as alleged in the indictment, right?
Yes. So
And
if
it's not the non-criminal objectives of the conspiracy, is it?
If I wrote a haiku that didn't talk about other gangs or violence or anything else, I don't think that would do it. I agree. But the point is, that overt act doesn't get mutated into a full-fledged attempt or conspiracy of its own.
Oh, yeah, I
Because
know.
otherwise the
I mean, it
statute
can
would say
be,
that.
we're going to kidnap whomever,
Yeah.
and then we're going to kidnap their daughter or whatever. If I go by rope, that's not illegal, but that's an overt act in furtherance of our conspiracy to do bad things.
You drive by the house and you say, yeah, they're home.
Yeah.
Okay. It's
Okay.
not illegal to drive by the house, and it's not illegal to look in the window, but if
Okay.
it's part of that conspiracy, yeah.
Yeah, but the objectives of the conspiracy, I mean, the objectives, so in the indictment, there are these objectives of the enterprise, YSL, listed out, some of which
5, I think.
are criminal and some of which would not be criminal.
They have, some have non-criminal aspects to them, yes.
Some are entirely non-criminal.
Right.
And so an overt act to further one of those things would not equate to a crime, assuming all of the other elements are there,
I understand what you're saying.
right?
I think that's correct.
Legally correct? Okay.
It says, the statute says an overt act to effect the object of the conspiracy. It speaks in the singular, it doesn't preclude the
Right.
plural.
And that has to be a criminal object, right?
We're talking about, well, the object is ultimately to violate a substantive provision. And I'm not trying to mince words, I'm thinking along with you.
Yeah.
But if you're forming an enterprise, remember that an enterprise can be legal.
Yeah.
And so if I form an enterprise as part of this, like different from this case, but an example, I form a corporation, but I'm forming the corporation as part of a securities fraud scheme or a money laundering scheme or something like that.
Mhm.
That can be an act overt act in furtherance of the objectives of the conspiracy. It is not itself illegal. I think we all agree the overt act itself doesn't have to be illegal.
Right,
The statute says to effect the object of the conspiracy.
right. And when it says to affect the object of the conspiracy, implied in there, but necessary, is it has to be a criminal object of the conspiracy, because it wouldn't be a conspiracy if it weren't an agreement to do something criminal.
We wouldn't be charging a conspiracy to comply with the law. That's correct.
Okay.
Yeah.
All right. Anybody need any further exposition before we get more detailed tomorrow?
No, I just want the opportunity to respond tomorrow. That's all.
Oh, absolutely. And if you want, I mean, it's only 4:20, so if you want to respond to anything right now, go ahead. But y'all wanted the afternoon to work on the directed verdict, so.
And I'm going to reiterate my humble request of the state in an effort to get to the bottom of the directed verdict stuff and arguments. I know you're busy. Could someone please send over email copies of the exhibits that you have admitted? Because I think they were giving us, for most of the trial anyways, PowerPoints of the upcoming exhibits. And I think that would cut to the chase about a lot of these directed verdict, because my memory is not perfect going back 8-9 months.
I believe Ms. Knight has started, and I thought she sent the link. I'm confirming. Are there
Okay.
certain acts that you want, because of the amount of media in some of them, they're taking a little longer? Are there certain acts, and we can talk offline.
Yeah,
There's
yeah,
certain
yeah.
acts that we can start with first, and then get
Okay.
the other ones up.
All right.
And I assume you'll have, if you find it, whatever that law is that you were talking about on the gun count.
Yes, yes, Ron, I will forward the case.
All right. And then y'all will have specifically a list of evidence that exists and is admitted in this trial to support every one of these counts, right? Because I'm assuming, I mean, I don't know what they're going to move for directed verdict on, but you'll have the answer as to whether there is evidence to support it. Okay.
And I'm just trying to.
All right. By tomorrow, when we take this up in the morning, like, I don't want you to say to me, oh, now that I've heard what the directed verdict is on, let me have the next 4 hours to get my response together. Because we talked about this a week and a half ago, that we were getting to this point and y'all needed to be ready with whatever y'all were going to say as the defense and whatever you were going to respond to as the state. Okay. All right. See y'all at, we want to say 9? Okay. See y'all at 9.
Thank you, Your Honor.
y'all see me? Okay, I'm about to end this stream and I'm gonna go live in an hour. Okay, I might do members only, but I'm driving right now. So I'm ending the stream. I can't believe y'all still on here keep keying in the chat with nothing showing. I'll see y'all in an hour.